Good morning. I'm the Code Enforcement Special Magistrate for today's hearing. I want to begin by explaining how the process is going to work. We generally hear building cases on the agenda first, and the city will call the cases in the order which they appear on the agenda. If you've appeared at today's hearing, your case will be called before those where no one has appeared, but that's only true if you've signed in. So if you haven't signed in, please make sure you sign in on the sign-in sheet in the rear. Once your case is called, I ask you to come to the podium on my right-hand side. The city will put on its testimony and evidence first. You will have an opportunity to review the evidence and ask questions of the city's witnesses. You will also have the opportunity to testify and present me with any of your own evidence. Once I have all the testimony and evidence, I will make a ruling. I will also enter a written order either today at the hearing or in the next few days, which you will receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not a formal courtroom. The formal rules of evidence do not apply here, although all testimony is taken under oath. So if you're going to testify or you think you might testify, or there's a possibility that you might testify, I'm going to ask that you stand and raise your right hand so that I can swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Please be seated. The city can call their first case.
Agenda item number 1, case number CE 21090227, case address 1219 George Avenue.
I'm Jonathan Cooley, C-O-O-L-E-Y. The address of 1219 Georgia Avenue, I witnessed work being performed without permits. They had new ACs being installed. I could witness from the exterior only new electrical conduit and new plumbing conduits. There was no access to the house, and the workers wouldn't answer the door, so I had no, but once checking the computer, there was no permits for the house.
Inspector Cooley, how was service done in this case?
I'm sorry, say it one more time.
How was the service done in this case?
How was the
Service.
the service?
Yes.
What do you
Notice.
The notes?
Notice.
The notice. Oh, I'm sorry. Gave a red tag on 9/17/21. Posted it on the door. Like I said, nobody would answer, so taped it to the door, and had contact with a homeowner and a general contractor a few days later, and that was the last of contact.
Inspector,
Yes.
did you also post City Hall?
Yes, on that was on 2/17.
And was the notice sent out by certified mail?
Yes, it was delivered to an individual on 2/24.
Was it sent out also by regular mail?
That I'm
Do you have an affidavit of posting?
yes,
Okay.
Yes.
And what date is that? Do you have the date on that?
2/17.
Okay, very good. Thank you.
Did you reach any conclusions with your conversations with the owner and their contractor?
He was supposed to get back to me, and he was supposed to begin the process of pulling permits, but at this time, they have still yet to even apply for a permit. So I'm looking for 90 days to obtain permits and complete work, and then $50 violation thereafter. $50 per day, I'm sorry.
Inspector, do you believe that 90 days is a reasonable amount of time to get that permit and work done?
I believe so. At the time of finding the work, it was fairly completed.
Is anyone here on behalf of the respondent? All right, I'm sorry, go ahead.
Special Magistrate, the city would like to submit as evidence a copy of the documents in the file, including but not limited. Well, actually, let me do this. Inspector Cooley, do you have any photographs of what you observed?
I didn't print them, I'm sorry.
But do you have them in the file?
Not in, yes.
There's photographs in the file? Okay, there we go. We're looking right now at some photographs of 1219, is that accurate? 1219 Georgia Avenue, is that accurate?
Yes, ma'am.
Okay. Special Magistrate, I'm sorry. The city would like to submit as evidence a copy of the documents in the file, including but not limited to the stop work order, the notice of violation, the certified mailing receipts and documents, the affidavit of posting, the photographs, and any other documents that are in the file.
Without objection, I'll enter the case file into evidence as the city's composite exhibit 1. In case CE 210902227, to make the following findings of fact and law, I find notice is sufficient. I find the property in violation of the listed code sections. Respondent has 90 days to come into compliance. Well, let me say for the purpose of the order, for failure to obtain permits for work that was observed being done on the property. The respondent has 90 days to come into compliance, or a fine of $50 per day may issue.
Thank you.
Agenda item number 4, case number CE 22010129, case address 5865 Caribbean Boulevard.
Good morning. Attilio Belisle, inspector for the city of West Palm Beach. Property was initially cited on 1/8/22 for renovations being performed to approximately 47 apartment buildings and a clubhouse without proper permits. The property was, notice of violation was mailed on 2/17/22, sent by regular mail, certified mail, and proper posting at City Hall. The certified mail was signed for, but the certified mail was returned unclaimed undeliverable. The attorney for the property has made contact with me in regards to trying to proceed forward with gaining compliance. However, I have not yet seen any form of permit applications to rectify the situation in our system. The city is recommending 30 days to obtain all permits, and after that, $250 a day.
Inspector Belisle, did you also post the property?
Yes.
And could you describe a little bit more about your observations of these alleged violations?
The contractor was hired out of New Jersey that's performing the work, and they specifically work directly for this property owner. They travel around, I guess, to all their different properties and renovate them, and they were unaware of the permitting requirements that we have here in the state of Florida. I talked to the foreman that was on site, and I immediately told him that permits were required, and we had a meeting with all of our chiefs from every discipline: electrical, plumbing, mechanical, and building out there at the site to give them the courtesy to apply for the permits. Unfortunately, the contractor's foreman that was on site does not have the ability to obtain the permits. The apartments in question had been renovated, and now new occupants are living in these apartments with electrical that has been altered, plumbing and mechanical that has been altered, without having any benefit of permits or inspections.
Can you specifically talk to what you observed on, because you basically told me they performed,
Sorry.
You basically told me they performed work without a permit, but what I need in order to make an order is I need factual information. In other words, I need to know what you saw that constituted work that required a permit.
Every apartment building for 47 buildings, and every building has approximately 5 to 6 units in each building. There's approximately 47 of those buildings, and then a clubhouse. The electrical, the plumbing, and the building has been altered and demolished, and everything new installed.
Okay. Is 30 days a sufficient amount of time for them to obtain permits for these 47 buildings?
Yes.
Presumably they're going to have to hire a licensed contractor in Florida?
Absolutely.
Do they understand that?
Yes.
Is anyone here on behalf of the respondent?
Inspector Belisle, do you also have photographs that document your observations that are in the file?
Yes, I do. The file has all the photos from the property at hand. If you see on some of these photos, A lot of the electrical concrete has been removed from these apartments.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the documents in the file, including but not limited to the notice of violation, the certificate, the certified mailing documentation, the affidavit of posting, and all photographs.
How many photos are there?
It's 47 buildings. There's a lot. If you zoom out, Monique, zoom out probably a couple more.
Is there any way we can flip it so that the pictures are bigger than the picture of the room? Because I get a little window on the pictures and a big window on the room.
Okay, so I can describe as we go through. This is the irrigation system. I believe this property is 22 acres, I believe. If I'm not mistaken. It's a large piece of property for this apartment complex. That's just showing the irrigation, all the irrigation system that was installed. If you want to go page by page, I can tell you what every picture is.
Well, if the city wants to submit them in evidence, I got to look at them.
That's all the irrigation and the trenches, the electricals and inside those ditches as well.
Officer, you took these pictures?
Yes,
Are they a fair and accurate representation of what you saw?
yes. That's the new bathtub. This is a typical unit. Every unit gets a new front door, gets a new bathtub, gets a new air conditioner with, they've taken out the soffits and new electrical, and they're completely revitalizing every single apartment unit in this property.
And they didn't think this needed a permit?
No, sir. That's the new electrical. So every unit didn't have a ceiling fan. So now they ran new electrical up you can see the new wire if you go to the next photo. That's the AC ripped out. Go to the next one.
Can they get a permit for the whole building, or do they need a permit for each unit?
They're probably going to have to get a permit for every building, but it's going to cover all trades.
Okay.
If you keep on going, Monique, you'll see the remainder. See, there's the new wires that they've installed. They took out the soffits. That's in the bedroom where they ran to a switch box to install the fans. That's how they fished the wire up to the ceiling. They just drilled a hole and poked it through. So the ceiling fan literally has nothing to support it. New fences. That's their garbage can. That's how they chased the wire up to the ceiling.
Well, presumably it's going to take more
From
than
the
30
panel.
days to fix all this.
They've got a team of contractors there. Somebody has to have a license to do this. It's not that intense for them to apply for the permit to add ceiling fans and the water heater. This is typically a water heater is a turnaround permit if it's a like for like. So it's the same day. And adding a ceiling fan could not possibly take no more than 30 days to add. And this electrical issue has already been brought in front of magistrate last hearing. Our electrical chief had brought it forward, so they're already ahead of the game for electrical. There's the plumbing. More irrigation, timer, or solenoid valves with electrical in the ground.
Inspector Belisle, do you recall or have a note in front of you as to the identity of the attorney you've been communicating with?
I've been in touch with 2 different individuals. I don't know who has taken the case on.
Okay.
Because the individuals that have called me have indicated that they're representing them, But before they take the case on, they wanted to just talk with the code enforcement officer to find out a little bit about the backstory.
Thank you.
I'm not certain who actually took the case on.
Thank you.
Here's all the new irrigation on the back side of the property. That's the mains. Those are large lines. Here's the clubhouse. This was the window on the right that you're seeing in this photograph. That actually was the opening, the original entrance into this clubhouse. Now they've made a new entrance that did not exist, and these doors are a new entrance to the clubhouse. Inside of this clubhouse, they took a saw and cut out all the trusses and removed every truss that was in the ceiling without any engineering or any approvals. So if you go to the next photos, there's the electrical for lights.
It's amazing to me that all of these contractors, they have to know they would need permits.
This gentleman said that he's just a worker. See the entry? So where the entry used to be, the walkway did go into right where those windows are. That was the entry door if you move your mouse to the center of the screen. That's where the old doors were to enter the clubhouse. Now it's windows. Oh, go down. Okay. New electrical. These are all new windows. Here's all the trusses. So to my left of this photo, you're going to see another couple photos where the trusses have been removed. This is what the trusses did look like. And they're putting these metal gussets on the trusses and adding some cross members to support the load without any kind of engineering or approval or anything. They tore out that concrete beam. They tore out the wall. That was a load-bearing concrete lintel. They took out the side wall of the building. The trusses are now sitting on no load-bearing columns. And go up one, Monique, just one little bit. Okay, look on the ground there in that photo. That was concrete structural load-bearing walls that were supporting There's the trusses. Yeah, to go up, keep on going up. Okay, down a little bit. In this photo, that's rebar that came up through the concrete slab, tying into the rebar for the concrete block wall to support the load of the roof. Go down. Keep going. That's new lighting, new electrical, and a ceiling there. Keep going. If you could see in the top left, you see where they put the gusset. That's where they're trying to match and mimic the vaulted ceiling of the existing area there. Keep going down. There's all new electrical. Here's where they've modified, cut the trusses out, put the new beams across, spanning, and they've cut all of the members out of all the trusses, all the roof. And if you see in the left on that photo, if you scroll up, you'll see to the left side, you'll see how they've sistered it together and supported it. None of it was ever approved. If you go to the remaining photos, you're going to see the framing, interior framing that's for the clubhouse, electrical and plumbing where they've modified the slab. We're getting into the bathroom groups. There's the trunk lines for the plumbing. You keep going. There's the electrical that they've installed for it.
So your testimony, the remaining photos are going to show me evidence of building electrical, mechanical, or plumbing work that was done without a permit?
Yes.
Okay. All right, without objection, I'm going to enter in evidence the evidentiary case file in this case, including the photographs taken by the officer as City's Composite Exhibit 1, In case CE 220101129, I'm going to make the following findings of fact and law. I find notice is sufficient. I found the property in violation of the listed code sections, specifically for having building, electrical, and mechanical work as testified to by the officer and as shown in the pictures that was performed without a permit. Respondent has 30 days to bring the property into compliance or by obtaining the permits, or a fine of $250 per day may issue.
Agenda item number 5, case number CE 22010130, case address 5101 Caribbean Boulevard.
Attilio Belisle, inspector for the city of West Palm Beach. Property was initially cited on 1/8/22 for alterations to the exterior of the building, and it is believed to be the same. This is the same property owner as the previous case. There is a good possibility that these apartments have already been modified and owners are living in them. However, there's evidence on the site of new work that has been performed for mechanical, electrical, building, and plumbing. Property's notice of violation was mailed on 2/17/22, sent by regular mail, certified mail, proper posting on site. The certified mail was signed for. The property was also posted at City Hall. Photos have also been submitted of this work.
Inspector Belisle, was an affidavit of posting completed?
Yes, yes it was.
And what date was that, if you have it?
2/16/22.
Thank you.
You did post the property?
Say that again?
You posted the property?
Yes, I did.
So tell me specifically what you saw on this property, or if you want, just go through the photos.
If you can go through the photos, I can describe them as we go. So this staircase that they've constructed is for the tenants of this property to throw their trash over the wall into the dumpster.
So it's sort of like a
Unfortunately,
trash
the
sport
railing
there?
is not properly secured. The steps, if somebody was handicapped, they don't have the ability to get on this platform in order to dispose of their garbage.
This was clearly not permitted, right?
No.
Okay.
Same property owners, new air conditioners. And this property, even though it is owned by the same corporation, the property itself has not been represented by anybody. Nobody has contacted me about these issues. The back property, I have been contacted, and I have made contact with with people on it. But this front property have not contacted me about anything. The office.
The people that contacted you about the back property, did they affirmatively represent that it was only the back property they were speaking about?
They firmly believe that they're representing their client. So I don't know if they're representing the front property for CE 22010130 as well.
You might want to ask them.
Yes. And this is a manufacturer's label indicating that the serial number showing that the AC was replaced in 2021.
And there's no permit on file for them?
No. 2021, that's another unit, and there's multiple units on this property. There's too many to take pictures. I wouldn't have enough time to discuss all the pictures. They all look like this.
So all of the ACs on this property were replaced?
A good majority. A good majority. That's my posting. And that is their office, their management office for both properties.
Inspector Belisle, is that a stop work order?
Yes, that's the stop work order. If you're looking for the affidavit of posting, that did get that's another photo.
Would the city like to submit those in evidence?
Yes.
Special Magistrate, the city would like to submit as evidence a copy of the entire file. Documents including but not limited to the stop work order, notice of violation, affidavit of posting, certified mail documents, and the photos.
Without objection, I'll return the evidence to the city's evidentiary file as city's composite exhibit 1. What remedy is the city seeking here?
City is seeking 30 days and $250 a day.
Is anyone here on behalf of the respondent? In case CE 220101130, I make the following findings of fact and I find notice is sufficient. Find property in violation of listed code sections by performing work, mechanical, and building that requires permits. Give the respondent 30 days to bring the property in compliance by obtaining the permits, or a fine of $250 per day may issue.
Thank you.
Agenda item number 40, case number CE 2202-0195. Case address is 4401 Greenwood Avenue.
Good morning, Natalie Clark, City of West Palm Beach Code Compliance. 4401 Greenwood Avenue was cited on February 11th of 2022. The notice was hand-delivered to the owner on 2/14 of 22. City Hall was also posted on 2/14 of 22. Certified mail was sent on 2/14 of 22, however, it just says COVID-19. The property was cited for inoperative vehicle, numbering standards, prohibited vehicle and outdoor storage. The inoperative vehicle is the cars in the front of the property that the tires were being repaired or replaced. The numbering standard is just for missing numbers on the front of the structure. The inoperative vehicle is a trailer in the rear, the container, and the outdoor storage just for items that were being stored in the front. The property has since complied with all code sections with the exception of the prohibited vehicle. I have had contact with the property owner, and he is in contact with zoning regarding the trailer being permitted to remain on the property.
Officer Clark, we're seeing photos scrolling on the screen. Do those photos represent the observations you made
Yes.
of the violations on the property?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the documents in the file, including the notice of violation, the certified mailing documents, the photographs, and Officer Clark, was an affidavit of posting completed?
Yes, it has.
And the affidavit of posting, Special Magistrate.
All right, I'll admit those documents into evidence of the city's composite exhibit 1. Sir, can you tell me your name, please?
Presley Burrell.
So tell me what's going on.
Well, I got violated for the vehicles. My son's car transmission went out. Took longer than was expected to fix, so I ended up had to junk the car.
I'm sorry, your name was?
Presley Burrell.
All right, so you're the owner of the property, sir?
Yes.
Okay, so your son had the cars on the property?
Yes. Well, it's my car as well, but I was getting it fixed for him. I got violated. Transmission wasn't good that we bought, so we ended up having to junk the car.
What about the numbers and the,
Yeah, I changed the numbers on the mailbox and replaced the one that was on the door that was missing.
what's still at issue here?
The container in the back.
Container, the prohibited vehicle. So there's a storage container in the rear. I know he's in contact with the zoning department. Can you explain to the magistrate?
When I spoke to the zoning department, they said I have to get a structural engineer to sign off to make sure that the container is secure and it's wind compliance for the area that I'm located in. And that's what I've been waiting on to get contact. I actually spoke to one today, I have to email some more information to them, and then they could tell me what I need to do to get the permit.
How much time do you need, sir?
I would take 90 days. I'm just waiting to see exactly what they're going to do and how much it's going to cost for me to get it in compliance.
What's the city's position?
The city has no objections, based on the fact that, I know it'll take, some time for him to get the sign off from the engineer and then to submit the permit to the building department and then have the sign off. So, the city has no objections to 90 days, 90 days or $100 per day until compliance is achieved.
And everything else is complied except for the 9471C, the outdoor storage?
The outdoor storage is also in compliance. The only remaining violation is the 94-487B1.
Okay, so because they're being stored in that storage container?
Yes.
Okay. So the city wants to give you 90 days. I will give you the 90 days. All right, in case CE 220200195. I make the following findings of fact on the line. Notice is sufficient. I find the property in violation of 9447B1 because of the vehicles being stored in the container. I order the respondent to come into compliance within 90 days, or a fine of up to $100 per day may issue.
Thank you.
Good luck, sir.
Thank you.
Agenda item number 2, case number CE 22020153, case address 531 31st Street.
Good morning. John Frosco, West Palm Beach Code Compliance. The property was cited for no rental license and certificate of use. Property was posted on February 10th, and City Hall was posted the same day. Certified mail and regular mail was sent to two different addresses, one in the tax roll and the other one to the registered agent of the corporation. Shows that the certified mail was received.
Which one? Or both?
Both.
Okay.
I discovered this property, to give you a little background on it. The property has been declared a chronic nuisance, and there is an additional case for fines running on the front structure. The back structure is the structure that's rented. So when I was doing my inspections, I noticed that the back cottage was occupied. So I checked the water bill, and I found the number of the tenant. I called the tenant and confirmed rental occupancy. So
Is the city performing a service order on the front part of the property?
right, we have a service order on this property which was abandoned for the most part for a long time.
How long has that been going on?
I'm not quite sure because I took the case over, so
But the city is actually performing services on this property.
we were until it's occupied, then I stopped doing that.
That's an odd circumstance. I'm sorry, go ahead.
So I made contact with the tenants originally on the phone, and I asked them about maintaining the property and mowing the lawn and keeping it up because it was overgrown, and I gave them a little bit of what the city's requirements were. So I sent out the notice of violation, and I didn't hear from the owner of the property. And then when reinspection came up, I checked to see if, because a lot of times they make the application for the license, but then I don't get a phone call for the inspection and the follow-up. So I got the email address from the rental application that they made, and they did that at March 3rd. And then I got the ball rolling with that. And I had an inspection due on Monday, but nobody showed on Monday. So I actually spoke with the tenants, and they allowed me to do a walkthrough, and I went over a few things on the property, and there was like 7 violations that would keep it from passing its inspection.
So they
And I
applied for the rental license, but they didn't pass the inspection.
Right.
Okay.
But it's needed that the owner or their agent be there when we do the inspection so that we can point out exactly what's wrong, so there's no back and forth. And on that, so that they have to take that responsibility. That's about it.
What remedy is the city seeking here?
you know, given the light of, you know, their want to cooperate and their need to, I was going to suggest 30 days or $250 a day based on the history of this property. But I would suggest 60 days and $250 a day. And that's based on the history of this property.
Sir, can you tell me your name, please?
My name is Herb Grant.
I'm sorry, one more time.
Herb Grant.
Mr. Grant, what is your relationship to the owner, El Sun Realty?
My daughter.
Your daughter owns El Sun Realty?
Pardon me, sir?
Number 2.
Oh, I'm sorry, my bad. What is your relation to the owner, Escavel Corp?
That's my daughter. She's the owner.
Special Magistrate, may I jump in here? Officer
Sure.
Frasca, do you have an email from Ms. Grant, the principal of E.S. Covell,
Yes.
requesting that her father appear for her today?
No, but he could speak more to that than I can about their relationship, and I wouldn't doubt that he would have that responsibility, that she wouldn't give him that. So he could speak to that more than I could.
Officer Frasca, did you also complete an affidavit of posting in this file?
I did,
Thank you.
along with photos.
And what are the photos depicting?
The latest photos actually just cover the grounds and some of the violations that exist on the property when I did the inspection.
Special Magistrate, may I submit my evidence now?
Okay, so you're looking at that. Anything not intended to weather the outdoors shouldn't be stored outdoors. I explained to the tenant those indoor chairs.
We're just here on a rental license violation, right? And the permit doesn't
Right.
exist, so,
Okay, magistrate,
yeah, I don't know that, I don't need
Sir,
to. It's just a question of fact for me. Is it property being rented? And if it is there a rental license? Because that's the code sections at issue.
Right,
And you've already
correct.
testified to both of those. But I don't have a problem accepting the evidence, the case file in this case, including anything that you've collected here, but I don't need that factually to make a determination here.
Okay.
So Mr. Grant,
Yes, sir.
so your daughter is the owner of Escavel Corp?
Yes, Cavell Corp. Yes, sir.
Okay. And she's okay with you being here to represent her?
Yes, sir. And I was told that an email was sent off last night stating that request.
All right, so the city wants to give you 60 days to get your rental license, sir? Well, what do you think?
I will have to do that, sir. Yes, sir.
I'm sorry?
My answer is yes.
Yeah, okay.
Magistrate, we agreed to meet at the property right after this case, so.
Okay. All right, in case CE 220200153, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 18162A and 2232A. Specifically, there are renters on the property, and there is no rental license or certificate of use on record for the city. Respondent has 60 days to bring the property in compliance, or a fine of up to $250 per day may issue. Good luck, work with the city, and hopefully you'll get this resolved, sir.
Thank you, sir. Appreciate it.
Thank you.
Agenda item number 3, case number CE 22010281. Case address 121 Costello Road has complied. Agenda item number 6, case number CE 22010441. Case address 725 Newark Street. Confirming we have no other respondents present.
Is that it for sign-ins?
That's Don's case? Yes.
Is that it for sign-ins?
Yes.
Yeah. Even for us, that's a rather low proportion.
(725) Newark Street, Don?
725 Newark Street. Okay. Don Williams, Code Enforcement, 725 Newark Street, was cited for 18106A, clean and unsanitary condition, 7434A1J, garbage can placement, 9471C, outdoor storage. Cited this property on January 31st of 22. Certified mail was sent February 16th of 22, City Hall, and it's posted on, the property was posted on 3/3 of 22. No contact with the owner of the property, and all violations still outstanding as of yesterday. Our recommendation would be 10 days to comply, or $100 a day after that.
Officer Williams,
Yes.
did you also send regular mail?
I did. Regular mail was sent. Yes.
And was an affidavit of posting completed?
Affidavit posting was completed 3/3 of 22.
And are there photographs of your observations
Yes.
in terms of the trash and debris, garbage can, and outdoor storage? Could you describe the trash and debris and outdoor storage that you observed?
Okay. There's the trash cans and recycling bins on the property, and you can see buckets near the tree. Yes, some other photos as well. Got some more?
Oh, there we go.
Yeah. More trash and debris on the property in the front.
Special Magistrate, the city would like to submit as evidence a copy of the documents in the file, including but not limited to the notice of violation, certified mailing documents, affidavit of posting, and the photographs that we're reviewing.
What's the garbage can placement issue?
Right. Recycling bins there and the garbage cans out the front.
That's the garbage can.
It might be another photo, but it's another photo with garbage cans as well. There's there. Mm-hmm.
Okay. So basically, they just have to move the outdoor storage, clean up the garbage, and put the
Yes.
garbage can away? All right, without objection, I'll enter evidence. The evidence for a case file in this case is City's Composite Exhibit 1. Is anyone here on behalf of the respondent? Case CE 220104441. I make the following findings of fact on law. I find notice is sufficient. I find the property in violation of 18106A, 7434A1J, and 9471C. Specifically, I find that there is trash and debris on the property, that a garbage can is invisible to the public, and that there is outdoor storage on the property that is in public view. Respondent has 10 days to bring the property into compliance, or fine of $100 per day may issue.
Agenda item number 7, case number CE 22010452, case address 1305 Florida Avenue.
Don Williams, Code Enforcement, 1305 Florida Avenue, was cited on January 31st of 22. Certified mail was sent February 16th of 22. The property and City Hall was posted March 3rd of 22. I cited this property for 7434A1J, which is garbage can placement, and 78-6, which is the numbering standards. And my recommendation is 10 days or $100 a day fine. And as of yesterday, the violation still exists.
Officer Williams, did you also send by regular mail?
Yes, regular mail was also sent, yes.
And was an affidavit of posting completed?
Affidavit posting completed 3/3 of 22.
And did you observe that the trash can was visible to the public?
Yes.
Did you observe that there were missing address characters?
Yes.
And were those for the front and or back?
Front.
And do you have photographs that document your observations?
Yes.
Special Magistrate, the city would like to submit as evidence a copy of the documents in the file, including but not limited to notice of violation, affidavit of posting, certified mailing documents, and the photographs.
Where's the garbage can?
In the driveway. Up to. And there are some recycling bins out there also.
All right. Without objection, I'll enter evidence. The evidence for a case file in this case, including the photographs and notice documents, is City's Composite Exhibit 1. In case CE 220104552, I make the following findings of fact and law. I find notice is sufficient. Find the property in violation of 7434A1J and 78-6. Specifically, there is trash cans that are visible to the public, and there are missing address characters. Respondent has, what were you asking for, 10 days?
Yes, 10-100.
Days, or a fine of up to $100 per day, Mayor.
Thank you.
Agenda item number 8, case number CE 22020061. Case address is 114 South Olive Avenue.
Morning, Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 114 South Olive Avenue was initially cited on 2/3/22. First class and certified mail was sent on 2/4/22. The certified mail was returned. The property as well as City Hall was posted on 2/4/22. Excuse me. The property was cited for 18-105-J, non-residential paint. As of this morning, property has not complied. There are pictures of, there's some initial pictures of the wall in its initial state, and I noticed last evening it looks like some pressure washing had occurred. However, some painting is still necessary, and so in light of that, the city's requesting 30 additional days in order to comply, or a fine of $100 per day be imposed. I have had no contact with the owner or management or anyone for that matter.
Officer Williams, can you describe specifically the condition of the paint that you're concerned about?
If you look at some of the earlier photos, the walls were very dirty, stained, peeling, and again, as I stated on last evening, I noted that they had pressure washed them to some extent. They look better, however, it still requires paint.
I'm sorry, go ahead.
Officer Williams, did you complete an affidavit of posting?
Yes, I did.
Special Magistrate, the city would like to submit as evidence the notice of violation, affidavit of posting, certified mail documents, and the photographs.
Without objection, I'll turn to evidence. The evidentiary case file in this case is City's Composite Exhibit 1. You wanted to give them 30 days?
30 days.
You said you've had no contact with them, but I guess they must have gotten the notice because they did something, right?
Yeah, they did something which was nice. They again, at least they pressure washed it. It looks substantially better, but it does require some painting.
You believe 30 days is sufficient amount of time to do the paint here?
Yes, I do. It's not like they have to paint the entire building. It's just the north side of the building along the alleyway.
Fair enough. In case CE 220200061, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18105J. Specifically, it requires paint, especially on the north side of the wall. Respondent has 30 days to bring property in compliance or fine of $100 per day, Mayor.
Agenda item number 9, case number CE 22020226. Case address is 1500 Elizabeth Avenue.
Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 1500 Elizabeth Ave was initially cited on 2/14/22. First class and certified mail was sent on 2/15/22. We do have a signed certified mail receipt on file. The property as well as City Hall was posted on 2/15/22. This particular violation was brought to my attention by Caroline Puel. I forget exactly what her exact title is, but basically what she's responsible for is properties that have new build outs or they're changing the layout of a property and adding new structures or new openings or what have you. And she's responsible for the correct addressing of those properties, and she coordinates with Palm Beach County just to ensure that all that information is accurate. At any rate, the property was cited for 78-6-4, numbering standards, the color, of the numbers, 78-6-5, which talks about when the address characters are posted that they need to be visible. Also 78-6-1, numbers, size and type, which addresses the size of the numbers, and 78-6-6, which addresses posting the correct address. And so as of last evening, when I went out, there has been no change. The address characters have not been posted. So the cities, again, would like to give them an additional 30 days in order to comply, or a fine of $100 per day be imposed. And again, someone did sign for the certified mail. I have not been in contact with management or property manager, have not received any correspondence from them. So in light of that, again, the city would like to give them 30 additional days in order to comply, or a fine of $100 per day be imposed.
Officer Williams, was an affidavit of posting completed?
Yes, it was.
And we've been reviewing photographs while you've been testifying about your observations. Do the photographs accurately and fairly depict your observations?
Yes, those
violations?
photographs depict the entrances that should have address characters, at those doors or around those doors and so forth. And also at the entrances that look like garages, those should be posted with addresses as well.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, and the photographs.
Without objection, I'll enter into evidence those documents as City's Composite Exhibit 1. Officer Williams, there is one door that looks like it has a contrast.
Yeah, that one, that particular one, in fact, that's the only door that has an address. All the other doors, that one has been there from the outset. It's always been posted.
So that one's okay?
That one's okay. That's the only one that's
But what the
okay.
city's concerned about is the remaining doors to the property, which are separate businesses, I presume?
Well, once they're rented out, they will be separate businesses. They will be individual businesces.
But they would be like A or B or C.
Right, exactly.
Okay.
Yes.
And they lack currently.
And actually, these aren't really so much going to be like A, B, and C. They are literally given like different numbers. Like on that door, I think that one was 1500, and then another door is like 1520, and then another one's like 1530, and another one's like 1540. So there's a lot of different numbers, and I actually sent the copy of the email, which had a diagram attached to it. I actually included that in the notice of violation, along with Caroline Puel's contact information, so that they could get clarification if they were not 100% sure.
Seems like a relatively easy fix, no?
It really is. It's a very easy fix, and so I was a little bit surprised that no one actually did anything. They've had a lot of renovations going on at that particular building. You know, they have some really nice tenants there, and so I actually thought it would be something that they would take care of rather immediately.
Well, you did manage to hit almost all of the numbering ordinances, so that's
Yeah, so we wanted to make sure that they were, that they were clear on it.
Officer Williams, we're looking on the screen at a copy of an email. Is this the email that you just testified to was sent in the notice of violation?
Yes, I included that notice from Caroline Puel as an enclosure with the notice of violation, and also it actually shows, if you look at it, it actually shows what address numbers should be posted and where they should be posted.
Thank you. Special Magistrate, the city would also like to submit as city's Exhibit 2 a copy of this email.
Without objection, admitted as City's Exhibit 2. All right, in case CE 220202226, I make the following findings of fact on live find notice is sufficient. Find the property in violation of listed code sections for not having numbers consistent with the requirements of the city code. Respondent has 30 days to come into compliance or a fine of $100 per day may issue.
Thank you.
Agenda item number 10, case number CE 22020013. Case address is 5110 Foxhall Drive.
Good morning. City of West Palm Beach Code Compliance Officer Paul McFarland. On February 1st, 2021, the property at 5110 Foxhall Drive South was cited for repair of roofs and walls, exterior paint required, clean and sanitary, garbage can placement, and address characters not posted on structure. The property, as well as City Hall, was posted. Affidavit of posting is in my case notes. Certified mail as well as regular mail was sent February 2nd. Certified mail was returned February 7th. As of Monday, the property has come into compliance with the trash can placement. All other violations still remain. On February 1st, I did try to knock and make contact with the property owner, Mr. Hardy, because we did have dealings in the past with the same issue, which he did repair. But it has since deteriorated as depicted in my photos. There's a lot of rotten wood to the fascia boards. There's some shingles that need to be addressed. At the time that I did make contact with a young lady that used to live at the property, she stated at the time that she did move out because of the condition of the roof, but she did not invite me in to document the condition of the inside. With that being said, City is recommending that the clean and sanitary and address characters come into compliance within 15 days or $50 a day. And for the exterior paint and the repair of roofs, City is requesting 90 days to bring that into compliance, or $50 a day until compliance is achieved.
Officer McFarland, we've been reviewing photographs during your testimony about your observations of the violations. Could you just describe where the exterior paint is required, or perhaps it's every place?
We'll have to go through them again. Exterior paint is going to be required to the fascia boards. That's one. If you keep scrolling around to the front entrance, you'll see where there's some discoloration. Right there, right there. Along that window, there's discoloration. It's going to need to be painted. All the fascia boards are going to need to be repaired and painted.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
Without objection, I'll evidence those documents as City's Composite Exhibit 1. So, I mean, it sounds, I mean, there's like two serious issues, right? The roof repair and the rotten wood, and then two sort of relatively quickly issues, pressure cleaning the walkway and the front door and the character address characters?
Yes.
And currently, there are no address characters on the structure?
No, I know that the paint, they're gonna have to get approved through HOA to even make the painting. So that's why I'm adding that into the 90 days with the roof. And he may need permits for the roof repair.
All right. In case CE 22020013, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 18103B, 18103J, 18106A, and 78-6. As to 18106A and 78-6, I give the respondent 15 days to bring the property in compliance, or fine of up to $50 per day may issue. Specifically, I find that there are missing characters on the structure and that the walkway and front door need to be clean. As to 18103B and 18103J, I give the respondent 90 days to come into compliance, or a fine of up to $50 per day. Specifically, I note that there is rotten wood that needs to be repaired and painted, both on the roof and on the faucet fascia.
Agenda item number 11, case number CE 22020014. Case address is 5120 Foxhall Place.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On February 1st, the property at 5120 Foxhall Place was cited for exterior paint. As exterior paint, landscape maintenance, vegetation needs to be trimmed back away from structure. Inoperative vehicle, no legal tag displayed on vehicle. And address characters, no address characters displayed on structure. The property, as well as City Hall, was posted February 4th. Certified mail and regular mail was sent February 2nd. Certified mail was returned February 12th. My affidavit of posting is attached to the case notes. As of Monday, I did make contact with the property owner, David Owen. He did disclose that the property is currently a rental property, and he does live out of state, so he's trying to coordinate to try to get the property into full compliance. As of Monday, all violations still exist. Mr. Owen is requesting additional time to get the landscape sorted out and the paint, which has to go through his HOA. So he's requesting additional time for the paint and the landscape. With that being said, city's recommending 60 days to come into compliance with the exterior paint, the landscape maintenance, or $100 a day until compliance is achieved. As for the inoperative vehicle and the address characters, city's recommending 15 days to come into compliance, or $100 a day until compliance is achieved.
Officer McFarland, do you have, we've been reviewing photographs while you've been testifying. Do you also have an observation about what observations you had of the paint that is needed?
Excuse me?
I'm sorry, do you also have more observations about what it is that needs painting?
If you can see right on either side of the garage there, you can see discoloration in the paint.
Are there any other areas besides that that you observed that need paint?
That's the only areas I observed.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documents, and photographs.
Without objection, I'll enter those documents as evidence as city's composite exhibit 1. where's the dead vegetation?
Right there, the palms that are approaching onto the structure. If you continue around that tree that's right next to it, it's also approaching onto the structure. They all need to be trimmed back and cleaned up.
And that car in the front, that was the inoperable vehicle?
If you go back to the Jaguar in the driveway, there's a expired tag sticker.
Okay.
Tires are deflated. Tires are also dry rotting. It's a good indication that it's been there for years and has not been operable.
And there's,
I did speak to Mr. Owen in the past about this same Jaguar. He did put air in the tire, but I did notice when I went out there, the tires are starting to dry rot. I mean, there's a garage
I'm good.
right in front of
You
where it's parked.
had me at the license hasn't been renewed.
No,
The number standards, there's numbers missing from the front of the house?
none. There's none on any other structure.
Okay. All right, in case CE 22020014, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18103J, 18106K, 34102B, and 78-6. Specifically, there is exterior paint needed on the front, at the lower part of the side of the garage. There is vegetation that needs to be maintained and cut back from the side of the house. There's an inoperable vehicle parked in the front of the property, and there are missing numbers. As to 18103J and 18106K, respondent has 60 days to come into compliance or a fine of $100 per day may issue. As to 34102B and 78-6, respondent has 15 days to come into compliance or a fine of $100 per day may issue.
Thank you.
Agenda item number 12, case number CE 22020134, case address 411 14th Street.
Good morning. Officer Phil Cartwright, City of West Palm Beach Code Enforcement. The property at 411 14th Street was originally cited on February 7th of 2022 for external doors and windows, clean and sanitary conditions, excessive overgrowth, securement of vacant property, failure to comply, and boarding certificate. Service was achieved by certified mail and actually sent on February 9th of 2022, as well as posted at City Hall. The property was posted on February 8th of 2022. All violations are still current. There has not been any contact by the owner. The city is asking that the property come into compliance with an additional 5 days or abatement.
Officer Cartwright, I apologize, I didn't hear whether you sent regular mail.
Yes, ma'am, I did.
Okay. And was an affidavit of posting completed?
Yes, ma'am, it was.
And could you please testify about your observations that support the alleged violations?
So this particular property, a year and a half ago, was under chronic nuisance. The police department had actually come there a couple of times and arrested several people due to prostitution and narcotic usage. At that point in time, the property was owned by a different company. So now it's under new management. I went out and observed all of the boards that are on the windows that are not actually done by the way that the city is asking. There's trash and debris throughout the property on the sides and in the front. I also went around to the opposite side of the property and took pictures from an adjacent parking lot showing some of the same violations.
And the photographs that we're seeing accurately depict your observations of the violations?
Yes, ma'am.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mailing documents, affidavit of posting, and photographs.
Without objection, I'll enter into evidence the documents presented as City's Composite Exhibit 1.
And Officer Cartwright, could you testify as to the abatement request that you're making? Do you believe that rises to the level of a health, safety, and welfare violation?
Yes, ma'am, I do.
And what is it that you believe
The property needs
rises
to
to
be,
the health, safety, and welfare?
the property needs to be boarded properly and securely. Currently, right now, the boards that are on the window were just put in by just regular screws. So anyone could go up there with just a regular drill or screwdriver and pull those off and gain access to the building.
And you're afraid that'll allow it to be continue to be used for habitat for or as a place for criminal activity?
Yes, sir, I do.
And the overgrowth on the property, do you believe that constitutes habitat for vermin?
Yes, sir, I do, especially towards the back of the property, yes.
So you're asking for 5 days to come into compliance or abatement on all of the listed code sections?
Yes, sir.
You said you've had contact with the new owner?
No, sir, there hasn't been any contact with any of the owners.
Have they shown any effort to try and bring the property to compliance other than the not properly boarded windows?
That is correct. It's basically a haven for people to go and hang out and do other different types of activities that basically involve the police department. So.
Which is a danger to the community and surrounding residents?
Yes, sir, that is correct.
All right, in case CE 22020134, I make the following findings of fact and law. I find notice is sufficient. I found the property in violation of 18103E, 18106A, 18106B, 18214B, 18215B, and 18265. I make further finding that said violations constitute a threat to the health, safety, and welfare of the city of West Palm Beach. Specifically, there are windows and doors that are not properly secured under the code. The property in the current condition is an attractive nuisance in the neighborhood, constituting a place where criminal activity is conducted. There's trash and debris on the property, and there is grass and weeds that are growing in excess of 6 inches. I order the property to compliance within 5 days.
Thank you.
Or I hereby authorize the city to enter the property and abate any and of all these violations. I hereby assess the cost of said abatement against the property and property owner.
Agenda item number 13, case number CE 2202-0138, case address is 1382 North Mangonia Drive.
Officer Phil Cartwright, City of West Palm Beach Code Enforcement. Property at 1382 North Mangonia Drive was originally cited on February 8th of 2022 for clean and sanitary conditions, excessive overgrowth, landscape maintenance, and failure to comply. Service was achieved by certified mail that was actually sent on February 9th of 2022, as well as being posted at City Hall. The property was posted on February 8th of 2022. All violations are still current. The city is asking that the property come into compliance within 5 days or abatement. There has been no contact with any of the owners.
Officer Cartwright, was regular mail also sent?
Yes, ma'am, it was.
Was an affidavit of posting completed and in the file?
Yes, ma'am, it was.
And could you please testify about your observations supporting each violation?
So basically, this was a call that came in from, I guess, neighbors throughout the community. The person that lived there was a resident who resided in that area for over 30 years that had passed away. They do have children that don't live in state. They have tried to, I guess, contact some of the relatives, but to no avail. They've had any success in doing so. So as you can see, the property is overgrown severely in the front, the sides. I was not allowed to go on to any of the adjacent properties, but from my understanding, it's basically overgrown in the back as well.
Officer Cartwright, could you describe what we're seeing in the photos with respect to the clean and sanitary, pressure cleaning of the driveway and
Yes,
sidewalk?
ma'am. The clean and sanitary conditions would basically be the black dirt that's basically collected in the driveway, as well as the sidewalk and the front of the property. So that would basically need to be pressure cleaned.
We've been reviewing photographs during your testimony. Do these photographs accurately represent your observations of these violations?
Yes, ma'am, that is correct.
And you're asking for an abatement. Do you feel the condition of the overgrowth constitutes a health, safety, and welfare
Yes.
issue?
Yes, ma'am, I do. Actually, one of the neighbors said that they trapped 2 raccoons at the back of the property and one at the front right in front of the hedges in front of the front of the house.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail, documents, and photographs.
Without objection, I'll enter those documents into evidence as City's Composite Exhibit 1. So there's nobody currently living here, is there?
No, sir, there isn't.
And to the best of your ability, there's nobody currently maintaining the property to the best of your observations?
No, sir, there is not.
And you believe that the overgrowth constitutes habitat for vermin?
Yes, sir, it does, especially with the testimony that I got from the neighbors about the raccoons.
All right, in case CE 22020138, to make the following findings of fact on life, I notice is sufficient. Find the property in violation of 18106A, 18106B, 18106K, and 18215B. Specifically, the driveway and sidewalk in front of the home need to be cleaned. There is grass and weeds in excess of 6 inches. The landscape has not been cut or maintained, and I make further findings that violations constitute a threat to the health, safety, and welfare of the city of West Palm Beach. Specifically, it constitutes habitat for vermin. I hereby order the respondent to come into compliance within 5 days. In the absence of compliance, you did say 5 days, right?
Yes, sir, I did.
Yeah. In the absence of compliance, I hereby authorize the city of West Palm Beach to enter the property and abate any involved violations. Hereby assess the cost of said abatement against property and property owner.
Thank you.
Agenda item number 14, case number CE 22010377. Case address is 122 Arlington Place.
Good morning, Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. 122 Arlington Place was cited on 127/22. Service was accomplished by certified mail sent on 2/18/2022. Certified mail was returned on 2/25/2022. In addition, both the property and City Hall were posted on 2/18/2022. The affidavit of posting is in the case notes and also in the attachments, the photo of it. I have had contact with the owner of the property, Michael George. The property was cited for 18-162-A rental license, 22-32-A certificate of use, and 82-151 engaging in a business without a license. As of this morning, the property has not come into compliance. Therefore, the city's asking for an additional 20 days for them to come into compliance. If they do not come into compliance, the city's asking for $100 a day until compliance is achieved. Now, I did speak with Michael George on 2 occasions. The licenses are paid for, but the inspection for code enforcement has not been done, and it's been like 2 months now. He's never gotten back to me, and every time I call, I get a voicemail, but he never calls back. And then also we're waiting for the state license because it's a short-term rental, and that's not in, he doesn't have the license for that either.
Sounds like this has been like chasing your tail here a little bit, huh?
Yes.
Officer Oliva, do you also have a record that notice was sent by regular mail?
I believe that's clerical. Clerical sends out that. I don't do it. I think that's in the case. Oh, it's okay. So then yes, yeah.
Okay. And we've been looking at some photos while you testify. Do those photographs show that the posting was made at the property?
Yes.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documents, and photographs.
Without objection, I'll enter in evidence those documents as City's Composite Exhibit 1. So there currently is a rental going on at this property, Officer Oliva?
I'm sorry?
There's a rental currently going on at this property?
Yes, he's doing a short-term rental there.
And as of the last time you checked, which I assume was recently, there is no license on file, either state or...
Yes, I checked this morning. They're still waiting on the state license for the short-term rental, and he still needs an inspection from code enforcement to go in and make sure there's minimal housing standards.
Fair enough. What remedy is the city seeking?
I'm giving him 20 days or $100 a day. until compliance is achieved.
So he just needs to have the inspection to get 18162A and 2232A cleared up, right?
Yes.
Do you have any idea what the delay on the state license is?
Nope. And when I spoke with one of the ladies out front, they say that it's not hard to get the state license. I mean, it comes pretty quick.
Just to be consistent, why don't we just make this 30 days?
Okay.
In case CE 2201037, make the following findings of fact and law. I find notice is sufficient to find the property in violation of 18162A, 2232A, and 82151 specifically. This is a short-term rental without a rental license from the city or the required state license. Respondent has 30 days to come to compliance or a fine of $100 per day may issue.
Special Magistrate, I apologize. I didn't hear if you accept the evidence.
You didn't hear me?
I didn't hear whether you accepted the evidence.
Oh, I don't know if I did or didn't. For the record, in case CE 2201037, I accept into evidence the evidentiary case file of the documents submitted by the city as city's composite exhibit 1.
Thank you.
Thank you.
Special Magistrate, we've had a respondent show up.
Okay.
They're here for multiple cases. I'm just writing down the list of them here.
Are they ones we haven't done yet, I hope?
We have not. They are here for agenda item number 30, 32, 33, 34, 35, 36, 37, 38, and 41. Appears to be all the same address, just different unit numbers, but I will go ahead and call them into the record. Agenda item number 30, case number CE 22020081. Case address is 3901 36 Court, specifically Unit C205. Agenda item number 32, case number CE 22020086. Case address is 3901 36 Court, Unit B203. Agenda item number 33, case number CE 22020087. Case address is 3901 36 Court, Unit B204. Agenda item number 34, case number CE 22020088. Case address is 3901 36 Court, Unit A206. Agenda item number 35, case number CE 22020089. Case address is 3901 36 Court, Unit B205. Agenda item number 36, case number CE 22020090. Case address 3901 36 Court, Unit C204. Agenda item number 37, case number CE 22020091. Case address 3901 36 Court, Unit A106. Agenda item number 38, case number CE 22020092. Case address is 3901 36 Court, Unit C206. Agenda item number 41, case number CE 22020243. Case address is 3901 36 Court. I think that's all of them.
Okay.
And the respondent needs to be sworn in.
Oh, have you been sworn? I obviously have
No.
not. Can you please raise your right hand? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury on the laws of the state of Florida?
I do.
All right, the city's going to present the case first, and then I'll allow you to respond.
Okay. Natalie Clark, City of West Palm Beach Code Compliance, 3901 36 Court, Unit C205. 3901 36 Court, Unit B203. 3905 36 Court, B204. 3905 36 Court, A206. 3905 36 Court, B205.
Officer Clark, are these 3901?
Yes.
Okay, you're saying 3905.
I'm sorry, 3901 36 Court. Do you want me to start over? What? I can start over.
Yeah, that's fine.
Okay. 3901 36 Court, Unit C205. 3901 36 Court, Unit B203. 3901 36 Court, Unit B204. 3901 36 Court, Unit C206. 3901 36 Court, Unit B205. 3901 36 Court, Unit C204. 3901 36 Court, Unit A106. 3901 36 Court, Unit C206. All of these units were cited for rental tax receipt and certificate of use. The properties were cited on February 2nd of 2022. The notice was hand-delivered to the property manager, Erica. She's here today, on 2/14 of 2022. And City Hall was also posted on 2/14 of 2022. The applications were submitted on February 18th of 2018. However, the inspections haven't, well, the units were inspected multiple times, some of them upwards of 7 times, which they did fail the inspection for different reasons. So the issue is rescheduling and getting the units in pretty much livable condition. The city is asking for an additional 15 days to have those inspections completed, or $200 per day until compliance is achieved.
Ma'am, can you tell me your name, please?
Erica Sanchez.
I'm sorry, the door was closing. Erica
Sanchez.
Sanchez. All right, Ms. Sanchez, what is your position with Piper Ventures LLC?
I am the property manager.
Okay, so tell me what's going on.
These were applied for before I started with the company, and then we had this whole COVID thing going on. I have addressed all the issues in the units. We just have to schedule and inspect.
The city wants to give you an additional 15 days to get that done. Is that a sufficient amount of time?
It is.
Okay, so I'm gonna make it 20 just to be safe here.
Thank you.
But I'm gonna give you 20 days, but you have to get the inspections and they have to be passed within those 20 days. Do you understand?
Got it.
I just want to clarify the record. Agenda item number 34, Officer Clark, you had said that that was apartment C206. That's a different apartment in a later case. Is this agenda number 34, is that A206?
A206, I'm sorry, is agenda number 34.
Okay. And each notice of violation on each one of these cases was hand-delivered?
Yes.
Is that your testimony? And was an affidavit of posting completed?
Yes.
And Special Magistrate, for these cases, the city would like to submit as evidence a copy of each notice of violation, each affidavit of posting, and this was also done by certified and regular?
Yes, certified mail was sent. The notice was hand-delivered, and as far as the mail that was sent, it just says COVID-19, so I'm not sure if it was signed for.
And the certified mailing?
All right, I will accept in evidence for each of these cases the documents presented by the city as City's Composite Exhibit 1 for each of these cases separately.
Thank you.
Okay, so agenda number item 41.
Well, let me finish with these before we go to 41, because that seems to be a case of a different kind of thing.
Okay.
All right, so as to all of the listed cases, and since they've been read 3 times, I'm not going to read them again. But all of the listed cases presented by the code. Ma'am, just for clarity, there's no dispute here that these are rental properties and that they're currently being rented? Or
Correct.
At least, okay.
Some of them are vacant, some of them are occupied, but they are for
But they're all
rentals.
currently for rent?
Yes.
Okay. All right, in the listed cases, except for case 41, I make the following findings of fact and law. I find notice is sufficient. I find the property is in violation of 18162A and 2232A. Respondent has 20 days to bring the property into compliance by obtaining the rental license and the certificate of use, or a fine of up to $200 per day may issue for each individual property. All right, so let's talk about 41.
Natalie Clark, City of West Palm Beach Code Compliance, 390136 Court, was cited on 2/15 of 2022. The property was posted on 2/28 of 2022, and certified mail was sent on 2/24 of 2022. The certified mail just says COVID-19. However, prior to the notice of violation being issued, I did have a conversation with the property manager on February 14th, which was the date that the other notices were hand-delivered for the rental tax. This is a repeat violation for clean and sanitary. The property has been cited several other times for the same code section 18106A, and it is a repeat violation. I do have, there are several other cases where that was cited. So one of them is CE 19010014. And the hearing for that one was held on January 16th of 2019. At that point, a finding of fact was issued for that case. Just 1 second. Okay, so the property was found to be in violation for 25 days. And at that point, the magistrate did order $200 per day for the 25 days, which totaled $5,000.
So this is a repeat violation?
Yeah, it's a repeat of a repeat. So it was found to be in violation 3 previous times. So for this case, the city is asking for, well, the property has been in violation since February 14th. As of yesterday, the property still remained in violation. So the city is asking for, well, the last time it was $200. So the city is asking for $500 per day until compliance is achieved, as it's a repeat of a repeat of a repeat.
Officer Clark, was regular mail sent?
Regular mail was sent.
And was the property posted and City
Yes.
Hall posted?
Yes.
Was an affidavit of posting completed and in the file?
Yes.
And we've been looking at photographs while you've been testifying. Could you describe a little bit about the current trash and debris that
Yes.
you feel you've observed on the property?
So basically, if you go through the photos, those are documentation of several different days of me just taking photos of the trash pile getting bigger and bigger. It's a mixture of construction debris, regular waste, and some of it is contained, some of it isn't. It just gets poured onto that pile. Some of those pictures were taken from the neighboring property, that one. So that's pretty much what you see from the neighboring property. Just a big pile of garbage.
That pile of garbage in whatever particular size, obviously it's progressively larger, that existed from February 14th and still exists today?
Yes.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, photographs, as well as a copy of the order existing in CE 19010014, upon which this repeat offense is based.
All right, I'll admit into evidence the documents presented by the city as City's Composite Exhibit 1. Ms. Sanchez, it looks like you got a pile of garbage on your property, huh?
Yes. Ms. Clark had mentioned that it was a repeated violation. The violations prior to that were many years ago before I took over the property. This specific one, we had a situation with Public Works where corporate office owed money for bulk pickup. And it took a long time to get all the accounting because my corporate office was with Public Works trying to figure out how much was owed. So they had stopped the bulk pickup during that time while they got everything settled down. I do have a bulk pickup scheduled for tomorrow. They cleared up the balance, everything, and it is scheduled for tomorrow. But I kept on calling on a daily basis trying to get this together, and it took that long to get it. Another situation that I'm facing with is that I do have people from outside of the property, people that don't live there, coming and dumping garbage in that area. So we're thinking about putting a camera or something to be able to see who's doing this, but they put couches, beds, mattresses, all kinds of big garbage. And some of the, my residents have noticed trucks coming in and dumping the garbage there. But I do have the scheduled pickup for tomorrow, and from there on, I have it scheduled for weekly pickup until we resolve the issue.
Does that affect how the city sees this?
Well, magistrate, as I've stated previously, the property has been cited a total of, I think, 8 times for the same issue. Sometimes it complied prior to the hearing, but as far as the repeat violation, this is like the 3rd repeat. So it was here before for a repeat. There was also one in 2021, so this is actually like the 3rd repeat violation. And while I do understand what Ms. Sanchez is saying, it is still the property owner's responsibility to ensure that we've had several conversations about having a roll-off on the property if they're doing the construction work. But as you can see, there's a lot of construction debris just on the ground. So we have discussed that issue with the roll-off, and that hasn't been addressed. So it's just those debris being thrown on the ground.
I mean, I could take care of the roll-off being there, but for the big bulk, the couches and stuff, I've scheduled a pickup weekly.
All right, what I'm going to do is I'm going to assess the fine, and I'm going to encourage you to get the property cleaned up as promptly as possible. And once you get it cleaned up, you can come back to whoever the magistrate is and ask for a reduction of this fine. But I'm in agreement with the city. This is a pretty substantial pile of trash that's sitting here in a neighborhood, and I imagine the neighbors aren't too fond of it. That kind of thing just can't happen. And if there are 8 previous citations for this is a recurring problem, one that I have to take into account.
I haven't had any citations. I mean, where was the last citation given?
The last one was in 2021, but prior to that, there were 2 other property managers before Ms. Sanchez. So regardless of who's the property manager, it is still the property owner's responsibility to ensure that the property is in.
Yeah, Ms. Sanchez, I recognize that obviously you weren't here for the duration of this, but unfortunately, I'm sure the neighbors have been. So in case CE 220-20243, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106A and 2635.
So how much
Hold on
are
a
we?
second, let me finish the order and then we'll talk. I make further findings said violation does constitute a repeat violation under the code of the ordinances of the city of West Palm Beach. I shall fine the amount of $250 per day. Beginning on March 14th. I'm sorry, what was the February 14th?
Actually, Magistrate, the city is asking for $500.
I know.
Okay, as of February 14th.
Yeah, on February 14th and continuing until the property comes into compliance. Yeah, that's my order. Go ahead, ma'am.
I just don't understand. I mean, we had an issue with Public Works. We were calling to get this picked up and get it resolved. We couldn't get it resolved because they were taking a long time. It's not like, I mean, that bothers me to see that pile of garbage, and it kept on getting higher and higher and higher, but it was an issue with Public Works.
If you notice, the city asked for a $500 per day fine. I cut that fine in half primarily because I do understand how difficult it has been. With that said, it's not City Works' requirement to take care to make sure that your property doesn't have trash on it. It's yours.
Okay, but I wasn't cited on February 14th.
Was that not?
I was not given anything on February 14th.
When was the notice?
Actually, Magistrate, I spoke to her verbally on the 14th, then the notice was sent on February 15th. So we spoke about it, and as you see, like when I handed her the postings for the rental property, you can see I was handling.
When did the notice happen? When was the property posted?
February 15th. February 15th.
Is that when the property was posted?
That's when the property was cited.
That's not for that case.
That's when we initially spoke about it. The date is.
That says 8106.
Is that for this case?
That's just the picture that I added. That's when I spoke to her, but the property was cited on the 15th. Can you go to the notice, please? The notice of violation.
Well, code says that repeat violations go from the citation of the repeat violation. So when was the repeat violation cited here?
Mo, can you go to the
And then it also says I have until March 10 to fix it.
Can you pull up the notice of repeat violation?
So with the repeat violation, magistrate, is the date that the notice was initially observed, which was on the 14th.
Can I
And
see the notice of repeat violation? That's too small for me to read. Can I get a document? Do we have the actual document? On my screen, it comes across as like a tiny little box. I need a document. Unfortunately, I got to see through 3.
Well, that's dated February 24th, right?
on the pictures are dated February 14th. That's initially when I spoke with Ms. Sanchez. At that point, she did tell me to give her a couple days because she would schedule it with sanitation. And as you can see, it was initially cited. I took pictures several days after that, prior to actually issuing the notice, because she did ask me to grant a couple additional days to call sanitation, which I did, but it wasn't picked up.
Special Magistrate 2635A indicates that the repeat, wait a minute, I lost it, I apologize. Beginning with the date the repeat violation is found to have occurred by the code inspector, and then the
2635B.
I'm sorry, sir.
2635B. Can you scroll up just a second, because the respondent said that the document said that she had a certain amount of time to correct, and I just want to see if that's true. Oh, this is... All right, scroll down. Ma'am, I don't see where it says that.
It says right there highlighted, by authority of City of West Palm Beach ordinance, the following corrective action must be taken by 3/10/22, 18-106-A.
And Magistrate, I did grant that time as a courtesy. However, it still wasn't in compliance even after I said the 10th. So we did speak. She did ask me for a few additional days to call sanitation. When I did speak to her after that, she stated there was a balance owed by the owner of the property from 2019. So that's the reason why the bulk wasn't picked up. However, even after granting an additional days as courtesy, it still wasn't picked up as of yesterday. The pile of garbage is still there.
It's scheduled for tomorrow.
I will grant that's true, but under basic due process, if the city says corrective action must be taken by 3/10, it's problematic for me to find prior to that date, even though the code allows me to do so. But the notice here suggests, and I take Ms. Sanchez at her word that she probably relied on that date. So I'm going to amend the previous order to begin the fine on 3/11/2022 and to continue until the property comes into compliance.
Special Magistrate, I was also handed additional underlying documentation by the code officer upon which the repeat is based, which I'd like to submit. And just for the record, the cases are CE 21060281, CE 19010014, CE 18090085, CE 21060281, CE 18090085, those are all the numbers. These are orders, notices of violations, liens, and affidavits.
All right, Ms. Sanchez, I'm going to begin the fine on the 11th of March, which means it's considerably less than it would have been otherwise, mostly because of the due process concern associated with that document. But it's important for you to realize a couple of things. One is the city, if they had, could have started a more substantial fine at an earlier date because it is a repeat violation. There are a number of different cases in this particular case. Even this fine is going to continue until you bring that property into compliance, which I guess is presumably tomorrow.
Yes.
But keep in mind that it still constitutes a repeat violation for the future. So in other words, if this happens again, the city can come back again. And I suspect if I'm the magistrate, the fine is going to be a lot more, just because I don't like seeing things repeated over and over again.
I understand.
But whoever the magistrate is, I'm sure is going to hit a much more significant fine as well. So it's very, very, very important that you meet with your principals and discuss exactly how you're going to keep this property clean, because the potential for fines is very, very substantial.
I understand.
All right. So in CE 220202243, make the following findings, fact, and law. Find notice is sufficient. Find the property in violation of 18106A. I make further finding that said violation is a repeat violation under the code of the city of West Palm Beach. I issue a fine of $250 per day beginning on March 11th, continuing until the property comes into compliance. And I order the respondent to cease and desist any more violations of 18106A.
Thank you.
Agenda item number 15, case number CE 22020303, case address 374 Maddox Street has complied. Agenda item number 16, case number CE 21120174, case address is 518 49th Street.
City of West Mutual Compliance, Robert Watkins. This property was cited December the 14th. Certified mail was sent December 15th. Certified mail was returned December 21st. City Hall was posted February the 8th. This property was cited for maintaining landscaping, garbage can placement, clean and sanitary, fence permits, fence repair, and outdoor storage. Complied violations are the clean and sanitary, fence permits, and fence maintenance because they took down the fence. Remaining violations that I observed are garbage can placement, maintaining of landscaping, and outdoor storage. I have had correspondence with the property management on January the 20th. She told me that the fence was going to come down and they should be wrapping up just regular maintenance work, but it seems like they were doing replacement of windows and all that, so I handed that over to building. But in my case, the city is requesting 30 days for all the things that are left out of compliance, which is the maintaining of landscaping, garbage can placement, and outdoor storage, or the city is requesting $100 per day after.
Officer Watkins, was regular mail sent?
Clerical did send regular mail.
Was the property posted?
Yes, the property was posted.
Did you complete an affidavit of posting, and is it in the file?
Yes, ma'am, everything is attached in Community Plus.
Would you please testify about your observations with the landscape that you believe is out of compliance?
Well, as the pictures depict, the landscaping is none there, actually. There's nothing there. There's mostly rocks everywhere. As the images also depict in the swell, there are bare areas where there used to be grass and there is no longer grass there.
And what is your testimony about the garbage can?
The garbage cans still remain, as the pictures depict, up front, right in public view, probably 10 feet off the sidewalk. Also, the outdoor storage is there as well. You can see in the pictures depict there's pallets and things of that nature outside as well.
And the photographs that we're reviewing
are all of the property and several different stages of the property.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documents, and photographs.
I'll admit the submitted documents and evidence of city's composite exhibit 1. So, Officer Watkins, if I understand correctly, the city is pursuing the issue of the landscaping, the garbage can placement, and the outdoor storage, but is not currently pursuing the fence permits or the wall maintenance?
No, those are compliant because she took down, well, the representative of the company, they took down the fence that was in the front.
So the fence is no longer an issue?
The fence is no longer an issue, or the repairing of the fence.
Okay. So we're just talking about the landscaping, the garbage can. Are we
And the
still talking
outdoor
about clean and sanitary?
Yep.
Yeah, because you just testified to that. And the outdoor storage. And you wanted to give them 30 days?
Yes, sir.
Have you had contact with them?
January I did, nothing after January.
Has there been any evidence they're attempting to bring this property into compliance?
They've took down the fence. I mean.
Yeah, I guess that's fair. But the trash and debris is still on the property as of the last time you were there?
Say again?
Trash and debris is still on the property as of the
Yeah,
last?
there's bottles and things of that nature that are out front.
Okay, in case CE 211-20174, I make the following findings of fact and law. I find notice is sufficient. Find the property in violation of 18106M, 7434A1J, 18106A, and 9471C. Specifically, the landscaping is not being maintained. The garbage can is in view of the public. There is trash and debris on the property, and there is outdoor storage occurring on the property. Our resident has 30 days to bring the property in compliance or fine of $100 per day may issue.
Agenda item number 17, case number is CE 2112-0175. Case address is 436 53rd Street.
City of West Metro Code Compliance, Robert Watkins. This property was cited December the 14th. Certified mail was sent December 15th. Certified mail was returned December the 20th. City Hall was posted February the 8th. This property was cited for 26-35-B, which is repeat violation, junk abandoned vehicle, fence and wall maintenance, and outdoor storage. Compliant violations are the abandoned junk and abandoned vehicle and fence maintenance. Remaining are the outdoor storage. I first spoke with this homeowner as well on January the 12th. She advised me that she would have someone clean up and everything gets taken care of. She has had the fence repaired and she has had the vehicle removed, but the outdoor storage, which is her repeat violation, is still there. The repeat violation stems from case CE 19110-312, and it was November the 23rd, 2019 for outdoor storage. It came into compliance February the 19th, 2020, which is also attached to the Community Plus case file. So for the repeat violation, the city is requesting $25 per day for every day after that. The repeat violation is still there, which is still currently, as of yesterday, is still in violation.
When did you observe the repeat violation?
December the 14th.
So the repeat violation's been running from December the 14th till today?
Yes, sir. I've been going by periodically, which some of the pictures will have different date stamps on it, taking the images, and I've also spoke with her again as well in reference to it, and it's still out there. She blames it on her tenants, but I told her being a property owner, it's her responsibility as well to stop by their property and make sure everything's cleaned up.
Officer Watkins, was regular mail also sent?
Yes, to my understanding, clerical did send regular mail.
Was the property posted?
Yes, the property was posted.
Was an affidavit of posting done and in the file?
Yes, it was actually in the case file as well. That was done too.
What are your observations of the current outdoor storage?
There's a hood on the side of the fence. There's several items stacked up outside as well on the east side of the property. There's hoods there,
And do your photos depict your observations?
as of yesterday, yes.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, certified mail documents, affidavit of posting, photographs, as well as a copy of the order and affidavit of compliance in the underlying case CE 1911-0312.
I'll accept the presented documents and evidence of City's Composite Exhibit 1. Officer Watkins, specifically the outdoor storage that's at issue is what?
There's several hoods out there. There's coolers and interior chairs that are on the east, southeast side of the property as well.
You said a hood?
She just went by. Yeah, there's a car hood on there.
Oh.
She went by pretty quickly, but if she goes back a few, you'll see the car hood is standing right along the fence line.
was wondering what a hood is.
Yeah,
A car hood?
Yeah, it's a champagne colored vehicle hood. Yeah, right there. Go back, just. Yeah, see it right there. She goes again, you can see the whole thing. It's also.
That's a car hood, huh?
Yeah, a whole car hood.
Ah. I'll tell you, my initial thought, that looked like a blanket, but yeah, that's a hard piece, right?
Mm-hmm. Yeah,
And-
the windshield wiper things come out the top and everything.
Yeah, that would be somewhat unusual to leave outside by a house, yeah. All right, and as of the best of your knowledge, when's the last time you were at the property?
Yesterday.
And the outdoor storage is still there?
Yes, sir.
All right. All right, case CE 211-20175, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 9471C, which is outdoor storage, including a number of items, including a car hood. I make further findings that violation constitutes a repeat violation under Section 2635B of the Code of the City of West Palm Beach. I hereby assess a fine amount of $25 per day beginning December 14th and continuing until the property comes into compliance.
Agenda item number 18, case number CE 21120198, case address is 5212 Pinewood Avenue.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited December the 15th. Certified mail was sent December the 16th. Certified mail was received December the 20th. Property at City Hall was posted February the 8th. This property was cited for clean and sanitary, repeat violation, junk abandoned vehicle, appliance door removal. There is an appliance that's outside, and outdoor storage. All violations have come into compliance. As of this moment, I spoke with the homeowner who actually came back and had everything cleaned up, everything removed. The city is requesting for the repeat violations, $50 per day for the repeat violation. It went for a total of 37 days, which would have been a total of $1,850.
Officer Watkins, are all of these sections repeat violations?
No, the repeat violations were for the outdoor storage.
9471C?
Yes, sir. And I could give you the case number if you're ready for it. It's repeat from KCE 200-70149. And it was for clean and sanitary, it was for clean and sanitary. And it was cited July 10th, 2020, complied October 19th, 2020.
I'm sorry, did you say the repeat violation was clean and sanitary or outdoor storage?
No, it was clean and sanitary.
It was clean and
Looking at
sanitary.
it wrong.
Okay.
Officer Watkins, was the notice sent by regular mail?
Yesterday, clerical sent regular mail.
Is there an affidavit of posting that's completed and in the file?
Yes, in Community Plus.
Would you please testify as to your observations of the clean and sanitary violation?
Yes, there are several trash debris out front, right below the mattress that was by the curb. On the east and west side of the property was also trash and debris litter outside the property as well. See, there's stuff all on the side of the mattress there, and
You're referring to the trash and
yeah, there was
debris that
trash
you're seeing?
right outside where the mattress was laying on the ground.
And those observations are depicted in the photographs that we're
Yes, they're in the
reviewing?
pictures that I took.
And is a copy of the underlying order upon which the repeat is based, is that in the file?
Yes, it's attached to the Community Plus file.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation for the instant case, the affidavit of posting, certified mailing documents, photographs, and for the underlying case of CE 2007-0149, copy of the order and affidavit of compliance.
I'll accept in evidence the documents proposed by the city as City's Composite Exhibit 1. So the trash and debris existed on the property for 37 days, is that correct, officer?
Yes, sir, until the homeowner contacted me about the violation and the repeat. And right after contacting him, within 2 days, he had his maintenance guys that are cleaning up the property again.
Officer Watkins, I apologize if I missed it. What was the first date of your observation that this was out of compliance in this case?
December the 15th.
Thank you.
All right, in case CE 2112019A, to make the following findings of fact and law, I find notice is sufficient to find the property in violation of 18106A. Make further finding that said violation constitutes a repeat violation under 2635B of the Code of the City of West Palm Beach. I hereby assess a fine for repeat violation from December 15th, was it?
Yes, sir, the 15th.
December 15th for the 37 days that the property was out of compliance in the amount of $50 per day for a total fine of $1,850.
Agenda item number 19, case number CE 22010155. Case address is 3900 Broadway.
City of Westminster Code Compliance, Robert Watkins. This property was cited on January the 11th. Certified mail was sent January the 12th. Certified mail was returned January 25th. City Hall was posted January the 12th. This property was cited for certificate of use, business tax receipt, and rental license. I myself have taken over this from our other officer who's no longer with the city. I did notice these things still out of compliance. I went there to do the rental inspection, which I also found that there was unpermitted work done, which depicts in the pictures. So in case they failed their rental inspection, I did speak with the owner and the business owner that's doing the other side of the property. We both collectively come up with 60 days, enough to get the required permits for electrical and plumbing of the things that were done. So the city is requesting 60 days to come into compliance, or $100 per day.
This is case 19.
Yes.
Number 19.
Officer Watkins, was regular mail sent of the notice?
To my knowledge, yes.
Was the property posted?
Yes, the property was posted.
Was an affidavit of posting completed and in the file?
Yes, it's in the Community Plus file.
Special Magistrate, I'd like to submit on behalf of the city a copy of the notice of violation, affidavit of posting, certified mail documents, and the photographs that we've seen of the posting.
Without objection, I'll enter those documents into evidence as City's Composite Exhibit 1. So you had a conversation with the owner, Union Mission Baptist Church?
Yes, sir. Actually, I had contact with Miss Clark, who runs it, and the gentleman, Isaiah, that's doing the funeral home next door, he ran into an issue with the city doesn't pretty much allow per zoning funeral homes anywhere south of 39th Street, and the church is actually south of 39th Street, so he had that issue as well. Then he had an issue with the state by it not being enough square foot to actually be called a funeral home, so they had to adjust that as well. But now we have the issue of all the unpermitted work that was done there, electrical and plumbing, that has to be addressed, and there's no permits on the file whatsoever for that work being done. So in all, he may not be even able to have that on the premises, but we've come up with the time allowed to work it all out and get it taken care of, to either scratch it or find a new location.
So the concern here is that they're running a funeral home on this property?
Yes, well, they want to run a funeral home there, but within over the 1,200 square foot that they wanted, and what they told me was included in that square footage, I've run into a lot of unpermitted work. So if there's unpermitted work there for electrical and plumbing, you weren't going to be able to pass for your business tax receipt, as well as zoning not approving a funeral home anywhere south of 39th Street, which the church is south of 39th Street. So that ran into another issue as well.
I get the business tax receipt. I think you made that pretty clear. The rental, is the rental to the
Well, because they own and they're renting out up under another business names for the funeral home at the church.
So they're going to need a rental license to rent a portion of the church to the funeral home business?
Yes, sir.
And they need a business tax receipt for the funeral home and a certificate of use, none of which they currently have at this time?
No.
Okay. I understand. That was a little more complicated.
Yeah, no, that's fine.
Okay. All right. In case CE 220101155, I make the following findings of fact and law. I notice is sufficient to find the property in violation of 2232A, 82144, and 18162A. Specifically, there's a business attempting to be started on the property that doesn't have a business tax receipt, or a rental license for the business on the property, or a certificate of use. Respondent has 60 days to bring the property in compliance, or a fine of $100 per day may issue.
Agenda item number 20, case number CE 22010124, case address is 626 39th Street, has complied. Agenda item number 21, case number CE 22010127, case address is 510 43rd Street. This case has also complied. Agenda item number 22, case number CE 22010190, case address is 3516 Greenwood Avenue.
Good morning. City of West Palm Beach Code Compliance, Officer J. Francis. 3516 Greenwood Ave was cited on 1/12/22. Certified mail was sent on 1/19/22. Certified mail was returned on 1/25/22. In addition, both the property and City Hall were posted on 3/3/22. The affidavit of posting was completed. I have not been in contact with the property owner. The property was cited for sod, grass, or approved plant material, documented through pictures, and expired rental license. As of this morning, the property has complied with obtaining a rental license, but have not come in compliance with the sod, grass, or approved plant material. Therefore, the city is asking for an additional 30 days for them to come into compliance. If they do not come into compliance, the city is then asking for $50 a day until compliance is achieved.
Officer Francis, was regular mail also sent?
Yes, ma'am.
Thank you. And we were seeing some photos. Could you describe your observations of what it is about the landscaping that you feel is out of compliance?
In the front yard, there's 75% mulch. I could go back, so that's the posting. Yes.
So the concern is that it's mulched instead of sodded, is that essentially it?
Yes, it should be 75% plant material. It's more mulched.
Can you're talking to the mic?
Oh, I'm sorry.
Yeah.
Yeah, it should be 75% plant material. Sod or approved plant material is mostly mulch.
Have you had a conversation with the owner about this?
No contact at all.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
All right, without objection, I'll enter evidence of those documents, the city's composite exhibit 1. All right, in case CE 22010190, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 94442C1. Specifically, the ground needs to be sodded and not mulched. I hereby order the respondent to come into compliance within 30 days or a fine of up to $50 per day may issue.
Thank you.
Agenda item number 23 is a duplicate of number 22. Agenda item number 24, case number CE 22010083, case address is 412 North Ware Drive.
Good morning, Officer Williams, Marcus Williams, City of West Palm Beach Code Enforcement. The address at 412 North Ware Drive was originally cited on January 6, 2022. The certified mail as well as regular mail was sent out January 7th, 2022. That was received on January 13th, 2022. The property as well as City Hall was posted on February 25th, 2022, and the affidavit of posting was put into the case file. To date, I've had no contact with the owner. They were originally cited for 7434A1J for their garbage can being in plain view of the public. 94482A for parking on the grass, as well as their driveway. I noticed it being in disrepair. And they were also cited for 9471-C for outdoor storage of various items that they had stored in the front lawn there.
As of this morning, 7434A1J has been complied. As far as the rest of the violations, they are still there on the property. I did check the system. It looks like they have applied for a permit to repair the driveway, hence all of the items that they have stored in the front lawn there. So the city is requesting 60 additional days to bring the property into compliance, or a $100 a day fine thereafter.
So the issue under 9442A is that they're parking vehicles on the grass part of the property. Is that what the city's concerned
Yes,
about?
sir. It was originally parked on the, I guess that would be the south side of the home there on the side. They have now moved it to the front swell of the property.
But either way, they can't park on the grass, whether it's on the side or the front.
Yes, sir.
The outdoor storage of the auto parts and building materials, is that still there as of the?
Yes, sir.
Okay.
A lot of it is what you see in the pictures there. It looks like stone bricks there that they plan to, I'm assuming, use to pave the driveway once they begin work.
Once they presumably get the permit from the city.
Yeah. Looks like the permit has been approved. They just need to come in and sign for it, and then
Pay
pick
for
it
it,
up.
probably.
Yeah.
Okay.
Special magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
I will accept those documents and evidence as City's Composite Exhibit 1. In case CE 220100083, make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 9442A and 9471C. Specifically, there are cars parking on unpaved surfaces, and there are storage of materials outside, including building materials. Respondent has 60 days to bring the property in compliance, or fine of $100 per name issue.
Agenda item number 25, case number CE 22010088. Case address is 429 North Ware Drive.
Officer Williams, City of West Palm Beach Code Enforcement. This address, 429 North Ware Drive, was originally cited on January 6, 2022. Regular mail as well as certified mail was sent out January 7th, 2022. That was returned February 1st, 2022. The property as well as City Hall was posted on February 25th, 2022, and the affidavit of posting was placed in the file. I had no contact with the owner. They were originally cited for 34102A for the junk or abandoned vehicle that was parked in the driveway of the property, 94482 for the driveway being in disrepair, and 9471-C for the various items stored on the side of the home and in the front lawn of the home. As of this morning, 34102A has been complied. The rest of the violations are still present at the property. The city is requesting 60 additional days to bring the property into compliance, or a $100 a day fine thereafter.
They're probably going to need a permit on that driveway.
Yes, sir.
Officer Williams, we've been seeing photographs that are up on the screen while you're testifying. Can you just briefly tell us more about your observations about what is the disrepair in the driveway and what is the outdoor storage?
Yes, if you can see there, various items that are stored on the property. Like I said, on the side of the home, and in the front lawn there. The vehicle has been removed, so that's been complied. And then as far as the driveway, you can see different areas of the driveway are cracked, stained, and that just needs to be repaired. To my knowledge, it might not need a permit, but I always tell, when talking to the owner or tenant, whoever, I always have them to contact the license and permit department and describe the scope of work to determine if a permit is needed or not. But again, I've had no contact with the owner or tenant there, so.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
I'll accept those documents and evidence as City's Composite Exhibit 1. In case CE 220100088, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 9442A, 9471C. Specifically, the driveway is in disrepair, cracked, and broken, and there are items, including junk items, stored outside the house. Respondent has 60 days to bring the property in compliance or fine of $100 per day may issue.
Agenda item number 26, case number is CE 22010169. Case address is 1908 Pinehurst Drive.
Officer Marcus Williams, City of West Palm Beach Code Enforcement. The property at 1908 Pinehurst Drive was originally cited on January 11, 2022. The regular as well as certified mail was sent out January 12, 2022. That was returned January 25th, 2022. The property as well as City Hall was posted on February 24th, 2022, and the affidavit of posting was placed in the file. I've had contact with the owner as well as the owner's legal representative. They were originally cited for 7431A1J for having their garbage can in plain view. When I originally cited them, I noticed that. 9471-C for outdoor storage. They had a lawnmower and various equipment stored in the driveway, as well as 18103B for the roof being in disrepair. After speaking with the owner, she did admit that there was a leak there in the roof. As of this morning, 7434A1J, the garbage can placement has been complied, as well as 9471-C, the outdoor storage. All of that has been cleaned up. The only matter that remains is the roof repair. They are right now going through litigation with their insurance company to get that taken care of. I placed a letter from their lawyer in the file stating that. So city is requesting additional 180 days, being that they're going through litigation to get that taken care of, or a $100 a day fine thereafter until compliance is achieved.
The disrepair of the roof is evidenced by that blue tarp in the photograph?
Yes, sir.
Officer Williams, do your photographs accurately depict your observations of the alleged violations on the property?
Yes, ma'am. As you can see in the picture, the blue tarp, there's the broken lawnmower as well as other things behind it. That's the trash can that was in view. Like I stated earlier, those two violations have been complied. It's just the roof leak that needs to be repaired and the tarp removed from the property.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, photographs, and a copy of the February 2nd, 2022 letter from the legal representative that the code officer testified to.
I hereby accept those documents and evidence as city's composite exhibit 1. In case CE 220100169, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of 18103B. Specifically, the roof is in disrepair. I give the respondent 180 days to come into compliance or fine of up to $100 per day may issue.
Agenda item number 27, case number is CE 22020183. Case address is 4110 Latonia Avenue.
Officer Marcus Williams, City of West Palm Beach Code Enforcement. The property at 4110 Latona Avenue was originally cited on February 10th, 2022. The regular as well as certified mail was sent out on February 11th, 2022. That was returned on February 18th, 2022. The property as well as City Hall was posted on February 24th, 2022, and the affidavit of posting was placed in the case file. To date, I've had contact with the owner. They were originally cited for 94482A for parking the white van on the grass there of the property, and for 78-6 for the numbering standards on the home there. They really just need to place a 0 at the end of it. As of this morning, 94482 has been complied. They've moved the white van seen there in the picture from the unpaved surfaces of the property. The only violation that stands is the 78-6. Like I said, they just need to literally place a 0 after the 411 there on the property to bring that into compliance. So the city is requesting additional 5 days to bring that into compliance, or a $50 a day fine thereafter until compliance is achieved.
And Officer Williams, you have a photograph in the file that we've seen that addresses the numbering standards, correct?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
I'll accept those documents and evidence as City's Composite Exhibit 1 in case CE 220-20183. Make the following findings of fact on the find notice is sufficient. Find the property in violation of 78-6. I'm going to respond at 10 days because sometimes it takes a little time to find those numbers, or fine in the amount of $25 per day, may issue.
Agenda item number 28, case number CE 220-20186. Case address is 1629 39th Street.
Officer Marcus Williams, City of West Palm Beach Code Enforcement. The property at 1629 39th Street was originally cited on February 10th, 2022. Regular as well as certified mail was sent out February 11th, 2022. That was returned February 15th, 2022. The property as well as City Hall was posted on February 25th, 2022, and the affidavit of posting was placed in the case file. I've had no contact with the owner. They were originally cited for 18106A, clean and sanitary conditions. There were trash and debris there present at the property. 18103B, they needed to repair the roof, walls, and the foundation there of the property. 18103J, paint needed on the structure there at the property. 18106B for the excessive overgrowth that's occurring at the property. 7434A1J for the trash can being in view of the public. 94402B.2-5, they have a real estate sign posted in the swell of the property that needs to be removed. 94442C-1, there's sod needed in various areas of the property. 94482-A for the driveway being in disrepair. As of this morning, all violations are current on the property with the exception of 18106B, the excessive growth. They have had someone come out and cut the grass. City is requesting 180 days to bring the property into compliance, or $100 a day fine thereafter until compliance is achieved.
Officer Williams, we've been reviewing photographs during your testimony.
Yes, ma'am.
Could you just describe very quickly what observation you had about the trash and debris, what you were seeing about the roof and walls,
Sure,
and everything else that's out
If
there?
you look right there on the east side of the property, excuse me, there's a bunch of used, it's just bags of trash that are on the floor, used items, different construction debris that have been, looks like they're gutting the inside of the home. I did notice that they did apply for several permits for work on the inside of the home. Looks like that work was started and it just wasn't finished. And then you see the trash can right there next to it, as well as the structure itself needing paint and several repairs needed to it. And then the driveway, of course, being in disrepair. It's cracked and stained in several places.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing documents, and photographs.
I'll accept into evidence those documents as City's Composite Exhibit 1. Are the portable real estate signs still out there?
Yes, sir.
Are they fixing the house and selling it at the same time?
It would appear so.
Okay. All right, in case CE 220-20186, I make the following findings of fact and life. I notice is sufficient. I find the property in violation of 18106A, 18103B, 18103J, 7434A1J, 9442B 2-5, 94442C1, and 9442A. I make specific finding that there is trash and debris on the property, including it looks like construction materials. There is rotten wood on the exterior. The trash can is visible to the public. There are portable signs on the property in the swale. There is missing sod on the front yard, and the driveway is in disrepair. I order the respondent to come into compliance within 180 days or a fine of $100 per day, may issue.
Thank you, sir.
Agenda item number 29, case number CE 2201-0005. Case address is 4100 Broadway.
Natalie Clark, City of West Palm Beach Code Compliance. I'm presenting this case for Officer Christopher Thompson. 4100 Broadway Avenue was cited on January 3rd of 2022. The property was posted on January 4th of 2022, and certified mail was sent. It was on January 4th of 2022. The certified mail was signed for. The property was cited for non-residential paint, clean and sanitary, excessive growth, junk and abandoned vehicle. The city would like to omit code section 94-482A. It was also cited for outdoor storage. Based on my observation, the property is in violation of code section 18103J. I did re-inspect the property yesterday. The paint is still in disrepair. The clean and sanitary has complied, which is code section 18106A. As for code sections 18106B, 34102A, which is the excessive growth, the abandoned junk and abandoned vehicle, and 9471C, which is the outdoor storage, I did not observe those code violations as they're in the rear of the property. And instead of complying those code sections, construction screening was installed to pretty much hide the violations. So the city, for code sections 18105J, which is the residential paint, the city is asking for an additional 60 days or $100 per day until compliance is achieved. As for the other code sections, the city is asking for an additional 20 days or $100 per day until compliance is achieved.
Officer Clark, do you have documentation that shows that regular mail was also sent as per an affidavit of posting?
The affidavit of posting is in the Community Plus, and it was signed by Officer Thompson, so yes.
Thank you. And does the affidavit of posting also reflect that it was posted at City Hall?
Yes, so it's signed that the property and City Hall were posted on January 4th.
Thank you. And we've been reviewing photographs during your testimony. Are these photographs that Officer Thompson took, or did you take any of the photographs as well?
Those photos were taken by myself yesterday.
Thank you. Special Magistrate, the city would like to submit as evidence copy the notice of violation, affidavit of posting, certified mail documents, and photographs.
All right, I'll accept those documents into evidence as City's Composite Exhibit 1. So the city is pursuing 18105J because you believe that the property needs paint,
Yes.
right? So, okay. All right, I see that. As to the excessive growth,
That is in the rear of the structure, so a construction screening fence was installed, so the city can no longer see the violation. But as you can see in the previous pictures, so we have no way of really telling if it's in compliance now because the screening was installed.
so how do I find them in violation if we can't see it?
Well, typically when the property is cited, it is the homeowner's responsibility to ensure that they're in compliance. Just installing the screening doesn't really constitute that the property is in compliance. So, and as you can see in some of the pictures, just from small portions of what I could see from the sidewalk, you can see that those vehicles are still there, as well as other items, but it's just not as clear as the pictures that were taken by Officer Thompson.
So you can still see the vehicles?
Yes, you can see portions of it still.
Can you see the excessive growth as well?
That wasn't clear because the screening is there.
What about the outdoor storage? Can you see any of that?
Those items you can partially see from the new pictures that were taken yesterday.
But you could see the outdoor storage.
The outdoor storage, I'm assuming, is whatever that trailer or other items are back there, and I couldn't see them clearly, but you could see portions of them, so.
You can see enough to identify that they're still there.
Yes.
Yeah, the difficulty for me is, remember, I have to make a finding that the condition exists on the property. So I agree with you that The solution shouldn't be to hide it from code enforcement officers, but on the other hand, I still have to be able to make a factual finding. I think I can do that based on your testimony as to 34102A and 9471C. I don't think I can do that as to 18106B. So this is what I'm going to do. In case CE 220100005, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18105J, specifically the exterior surfaces are in need of paint. I make a further finding that there's a violation of 34102A, that there are junk abandoned vehicles on the property that need to be removed. And I make further finding there's a violation of 9471C, that there is outdoor storage existing on the property that needs to be removed. As to 18105J, I give the respondent 60 days to come to compliance or a fine of $100 per day. As to 34102A, the junk or abandoned vehicles, and the 9471C, the outdoor storage, I give the respondent 20 days to come to compliance or a fine of $100 per day may issue.
Agenda item number 31, case number CE 22020083, case address is 925 37th Street.
Natalie Clark, City of West Palm Beach Code Compliance. 925 37th Street was cited on February 5th of 2022. The property and City Hall were posted on February 14th of 2022. Certified mail was sent on February 14th of 2022. The property was cited for 18-103E, which is broken windows. 18103J, which is exterior paint, 18162, the rental tax receipt, and 22-32A, which is a certificate of use, as well as 94442E, which is landscaping of the swale/parkway. So I've had contact with the property owner. The city is asking for 30 additional days or $200 per day for code sections 18162A, which is the rental tax receipt, and 22-32A, which is a certificate of use. For the other code sections, the city is asking for an additional 90 days or $100 per day until compliance is achieved. The rental tax receipt has been, the application for the rental tax has been submitted. It just needs to be inspected at this point.
Officer Clark, was regular mail also sent?
Yes, regular mail was sent, just as COVID-19. However, the owner has acknowledged receipt of the notice of violation.
And was an affidavit of posting completed and in the file?
Yes, that was completed on February 14th.
And are there photographs that depict your observations of the window or windows that need to be repaired, and the exterior paint and the landscaping?
Do you want me to explain? Okay, so what the windows in the front, sort of on the side, can you go through? There are several missing panels from that window. So the homeowner did advise that he did order it, but there's an issue with him receiving them. So he did request 90 days. As far as the paint, he has started pressure washing or stripping the existing paint to prep for the new paint. The landscaping of the parkway, it's just missing the sod. And we did agree on all of those items being done within that 90 days time frame.
Thank you. And your photos depict these observations?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mailing, documentation, and photos.
Accept those documents and evidence as city's composite exhibit 1. So they submitted for the rental license, they just need the inspection?
Correct.
And there is a renter on the property?
Yes.
All right, in case CE 2202083, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18162A and 2232A. As to those two sections, I give the respondent 30 days to come to compliance or a fine of $100 per day may issue. As to, I make further finding that the property is in violation of 18103E and 18103J and 94442E. Specifically, there's a broken window that needs repair, there is paint that is in disrepair, and there needs to be sod in the swale. Respondent has 90 days to bring those property into compliance or a fine of $100 per day may issue.
Agenda item number 39, case number is CE 22020155. Case address is 3321 Pinewood Avenue.
Natalie Clark, City of West Palm Beach Code Compliance, 3321 Pinewood Avenue was cited on February 9th of 2022. The property and City Hall were posted on February 14th of 2022, and certified mail was sent on February 10th of 2022. The property was cited for 18-103E, which is the broken windows up on the second level of the structure. 18103J, which is the exterior paint. 18106A, which is clean and sanitary. There's a lot of trash and debris on the property. 18-162A, which is the rental tax receipt. 18-265, which is the boarding certificate. 2232A, the certificate of use. 7434A1H, which is the trash can being in plain sight. 744B, which is the refrigerators being in plain sight. It's bulk goods. 94442C1, which is the bare landscape. Pretty much it's bare all over. There's no sod. 94442E, which is landscaping of the swale/parkway. It's the same issue. It's missing the sod. 9471C, which is outdoor storage, and that's for the boards being stored on the side as well as other items being stored outside. The property has since complied with 18103E, which is the window repair. 18103J, exterior paint. 18265, the boards were removed from the windows. 744B, the refrigerators were removed from outdoor. And 9471C, which is the outdoor storage. The property remains in violation of code sections 18106A, 7434A1H. So the clean and sanitary and the trash can placement, the city's asking for an additional 15 days or $100 per day. For code sections 18162A, which is the rental tax receipt, the 2232A, which is the certificate of use. 94442C1, which is the sodding of the landscape, and 94442, which is the sodding of the swale. The city is asking for an additional 30 days or $200 per day until compliance is achieved. I have had contact with the property owner. As far as the rental tax receipt, it's a change of ownership, so there is an application on file. It just needs to be updated to reflect the new owner.
So on the rental license and the trash can, you wanted to give them 15 days?
No, for the clean and sanitary and the trash can, it's 15 days or $100 per day.
And for the remaining, which is primarily looks like the landscaping and the rental license,
Yes.
you wanted to give them 30 days or 200?
30 days or $200 per day.
I'm sorry, I'll let you do the.
Officer Clark, was regular mail sent out for the notice?
Yes.
And is there a completed affidavit of posting and in the file?
Yes, that was completed on February 14th.
Thank you. And per your testimony, do the photos accurately depict your observations of the alleged violations?
Yes.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
I'll accept those documents and evidence as City's Composite Exhibit 1. All right, so in case CE 22020155, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106A, clean and sanitary, as there is trash and debris on the property. I make that finding. And 7434A1H, that there is a trash can in public view. I give the respondent 15 days to bring those into compliance, or a fine of $100 per day may issue. Make further finding that said property is in violation of 18162A, the rental license, and 2232A, certificate of use. Those need to be updated and completed for the city. I give the respondent, let me also make further finding that there's a violation of 94442C1 and 94442E. The property needs to be properly landscaped with grass in both the property and the swale. For all of those, I give the respondent 30 days to come to compliance, or fine of $200 per day.
Agenda item number 42, case number CE 22020350. Case address is 814 44th Street.
Natalie Clark, City of West Palm Beach Code Compliance, 814 44th Street was cited on February 25th of 2022. The property and City Hall were posted on February 28th of 2022, and certified mail was sent on February 28th of 2022. The certified mail was returned. The property was cited for outdoor storage. I've had no contact with the property owner. The city is asking for an additional 15 days or $50 per day until compliance is achieved. And the outdoor storage is just the items being stored in the carport. There are just several items there that just needs to be removed.
And Officer Clark, was notice also sent out via regular mail?
Yes.
And is there a completed affidavit of posting and in the file?
Yes.
And your photos accurately depict your observations of the alleged violation?
Correct.
Special Magistrate, the city would like to submit as evidence a copy of the notice of violation, affidavit of posting, certified mail documentation, and photographs.
I'll accept those items into evidence of city's composite exhibit 1. The city seeking 15 days or 150 in this case?
$50.
$50. And the city's concern in this case is the materials that were depicted in the photograph showing in the carport, it looked like?
Yes.
All right, in case CE 220-20350, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 9471C. Specifically, there are multiple items being stored in the carport. City has, the respondent has 15 days to bring the property into compliance, so fine of up to $50 per day, Measure.
Thank you.
Guess we're on to other matters. All right, if you're here for the other matters, and I suspect that's why you're here, we're going to proceed to those. I'm going to ask if the cases are going to be heard in the order in which they appear on the agenda. When you hear your case heard, go ahead and proceed to the podium on my right-hand side. The city will introduce the case. You'll have an opportunity to present your side of this case. In the case of fine reductions, which most of these appear to be, specifically, you need to tell me what specifically you're asking me to do, and tell me why I should do that, or why I should grant that particular relief. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify today, or you think you might testify, or there's a possibility that you might testify, would you please rise and raise your right hand? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida?
I do.
All right, please be seated.
Okay. Other matter number 1, 2, 5, 6, and 7 is regarding the same owner. Case number CE 06080768, case number CE 06090018. Those are the same address, 1177 Clare Ave, units 6 and 7. And then agenda items number 5, 6, and 7. That's case number CE 16050453, case number CE 18040311, case number CE 18080543, same address, 1156 Elizabeth Avenue. And the city has a stipulation and an order for the special magistrate to review.
Sir, can you tell me your name, please?
Yes, my name is Timothy Frank. It's spelled F-R-A-N-K, and I'm a representative of Charlotte Kellogg, owner of property.
You're an attorney, sir?
I am not.
He is a designated agent to appear here today. Special Magistrate, these cases are all in relation to 1177 Clare, also known as 1156 Elizabeth. The properties had several liens on them. It's one property, but it had 2 PCNs. And when this current owner who Mr. Frank represents, acquired the property. The county had some type of a problem with the PCN, and so they took on these liens without knowing about them. And then also several cases developed during their ownership. Today we're here to resolve all of those. They have submitted a lien reduction application, gone through all the requirements, and brought the property into compliance. The parties have entered into a stipulation and have agreed on a fine reduction to a total amount of fine of $15,000 to resolve all of these cases.
Are both sides satisfied with the stipulation?
Yes, sir.
Sir, are you satisfied with the stipulation?
Yes.
All right, I will accept the stipulation and adopt the stipulation agreement as an order of the special magistrate on the 16th day of March. Thank you both.
Thank you.
Thank you.
Agenda items number 3 and 4 is the same address. Case number is CE 10050629 and case number CE 16010341. Again, same address, 732 43rd Street.
Case CE 100-50629 was cited on May 21st, 2010 for failure to obtain a rental license and COU. Property was taken to hearing on July 21st, 2010. The property was given 30 days to comply, $100 a day. The property was out of compliance for 471 days, resulting in a lien amount of $47,100. The applicant is the new owner. The magistrate, the city is seeking 15% for case CE 16010341. They were cited January 12, 2016 for failure to obtain a rental license and COU. The property was taken to hearing March 2nd, 2016. The property was given 30 days to comply, $100 a day. Property was out of compliance for 1,919 days, resulting in a lien amount of $191,900. Again, the applicant is a new owner. Due to this, magistrate, the city is seeking 15%.
Ma'am, can you tell me your name, please?
Yep, my name is Astrid Jean on behalf of the new buyer, the new owner, Greets LLC.
I'm sorry, what is the name of the new owner?
Greet LLC.
Greet, like
so hard to pronounce.
Like greeting?
Yeah, like no, not like greeting. It's GREIT, I believe.
All right. So, what are you asking me for, and why should I grant it to you?
We're asking for admin fee and, $5,000 to $10,000 to settle both because since taking over the property, we've been trying to clear it, and the old owner.
Maybe you have to speak more directly into the
I
microphone.
apologize.
I can't hear you very well.
I cannot take my mask off, can I now?
If you'd like, it's up to you.
Thank you so much. We've been working with, the whole issue, I think, was a license to rent that the old owner is saying that they never had tenants in the property. It was their family. So they were working with the city initially, and then after that, whatever reason they give us to not continue, and we've been trying to really fix everything, to fix the lien accruing and make sure it's in compliance. So we're just asking the city to work with us because we went ahead and tried to take care of it ASAP. We were here last time, but the second time there was a foreclosure that came on it, and we didn't know about it, so we had to go back and to make sure that it was, they didn't address the city when they filed for foreclosure. So they agreed to also take care of it today.
So the city, if I understand the city's position here, has agreed to reduce it by 85% to 15% in both cases. So
okay.
From 47 to $7,065, and from $191,900 to $28,785.
Yeah, we just wanted to see if we could get, if the city will agree that to take 10 grand for both, if possible.
What's the city, the respondent has requested each to 10 grand, or
Combined,
are you looking for 5 grand each, essentially?
if possible.
I don't know, what's the city's position on that?
It's up to you, officer, if you wanted to talk with Mr. Joyce.
Yeah, I want to give us a moment to discuss it, if you can.
Yep, take a minute.
The city will consider 10 each.
Okay,
That seems pretty reasonable considering where the fines are, ma'am.
okay. Thank you.
All right, so in case CE, how much time do you need to pay?
Can we get, what is 45 days if it's possible?
Sure.
Thank you so much.
In case CE 1005069, I'm going to reduce the fine from $47,100 to $10,000 payable within 45 days. And CE 1601031, I'll reduce it to $10,000 payable within 45 days.
Thank you.
I think we're on 8.
Other matter number 8, case number is CE 19060548. Case address is 1913 Division Avenue.
Case CE 190600548 was cited on June 26, 2019 for failure to obtain a rental license and certificate of use. On August 7, 2019, the special magistrate ordered 30 days or $100 a day to comply. Property was out of compliance for 820 days, resulting in a lien amount of $82,000. Special magistrate, the applicant is a new owner. The city is seeking 15% on this property, but I did want to give some background knowledge. This new owner, although they did comply with this order, they were also cited for failure to obtain rental license and COU, and it was at this time that he discovered that there was fines currently running on the property for the same violations. He did mention that he had a title company do the research, and apparently they didn't do a proper job at it. But as I explained to him, that it's not the city's responsibility to stop a fine or identify when there is a fine currently running on a property.
Yeah, it sounds like your issue is with your title company, sir.
I did contact my title company, and they did, in the paperwork, they did notify myself and my agent that there was a lien on the property. So there was a violation on the property. I'm new to real estate, and I didn't pay attention to that. So once I found out that the liens were running, I got the letter on last year, May 28th. Once I found out, I paid the certificate of use right away, and for the past 3 years, and I started working on fixing everything I needed to fix to get it compliant. And I've always been in contact with Cassandra, and but the property is compliant now. So part of it is my fault.
Generally, I know they're in compliance because the city doesn't let you bring the reduction of fine unless they're in compliance, but it is good to know. The city has offered to reduce the fine from, I guess, $82,000 to $12,300. Is that 15%? I try and do the math fast.
Yeah, $12,300.
So that's the city's offer. What are you asking me for, sir?
I am asking for between $500 to $1,000, and that's because of the hardship I went through COVID. I have evidence of the hardship. When I took over the property, I didn't have, the tenants weren't, that's once, 2 months after COVID hit, the tenants weren't paying. I spent over $60,000 of my personal money trying to pay the lender to not lose the property. And I've been in financial hardship since then. I have evidence of that. And
Tell me about that. I can take, according to the city code, I can take that into account.
Yeah, so I used all my credit cards. I have evidence. I had to get a planner to actually help me and negotiate with the credit card companies, and I got all these loans, and it totaled to up to $60,000, and I've been trying to recover since then from my situation.
Special Magistrate, I also want to comment and say that this property, although the applicant is the new owner, they did just recently sold the property as well. In the midst of...
You don't own this property anymore, sir?
Yes, I just recently, it hasn't been completed just because of this lien. Because of all the debt I had, I couldn't hold the property anymore. I found somebody that was going to take over it, but this lien is actually is still my responsibility to make sure it's taken care of, or it's not going to be completed.
Did you escrow the money, or you just haven't sold the property?
Escrowed the money, sir. And I'm still at the loss of $80,000, between $80,000 to $100,000 from the sale.
I also want to make another note, apologize, that because that the property was sold according to the property appraisers, that I can't attest that the property is in full compliance for the lien reduction. It's just because of how the lien reduction is set up, being that it changed hands, and he was the one that brought it into compliance prior to, we actually had to take it to hearing. But I cannot say that the property is in compliance at the moment.
Sorry.
Well, it was complied at some point.
He complied with the rental license issue, yes. In the midst of us doing the application for the lien reduction, this is when the property was sold according to the property appraisers. So once the property gets sold, we no longer have access to that property in the middle of us doing the lien reduction. So I was not able to inspect it as I do with every other property. So I can't attest to the fact that the property is in full compliance.
But at one point, he paid the fee and was in compliance.
He paid the fee.
But you never did the inspection.
We could not do the inspection. He paid the fee for the rental license because he paid for the rental license, which is what he was running fines for. But it's not just, as the lien reduction application highlights, when you apply for it, the property has to be in full compliance. I can't attest to the fact that the property is in full compliance, but I can attest to the fact that he complied with what it was running fines for. Because at the time of his ownership, he did obtain a rental license.
Seems like a binary choice to me, right? It's either in compliance or it's not, right?
Can I speak to that, sir?
Yeah, go ahead, sir.
So all these happened within the past 4 months. I did get a rental license and certificate of use for September 2021. Inspection was done. I passed it. I currently have Section 8 in it, and this property was just recently sold 2 months ago. And
so it sounds like he came into compliance. He's got
with the rental license and COU, yes, he did.
Okay. And Section 8 as well, sir.
Unless the city attorney has a different view of it.
Special Magistrate, under 2639, there's a requirement for the lien reduction process that the applicant, if they are still the owner of the subject property, that they have a lien reduction inspection to ensure that there are no other violations.
Yes.
However,
but he's not the owner of the property.
He is no longer the owner of the property, so there was no ability for the city to do that inspection. 2639A8 addresses if the city is unable to do that inspection and confirm that compliance, then the special magistrate has to show that the applicant meets one of the following exceptions in sub A and sub B. If the prior owner of the property, if they're now the prior owner due to an involuntary transaction, which I don't believe it
no, I think he sold it, so I think that doesn't apply.
Right. And if it's due to a voluntary transfer or sale of the property to a third party, then they aren't permitted to apply for a year from the date of transfer. However, at the time that the applicant, this gentleman, submitted the application, at that time he was still the owner. So technically it complies with our subsection.
Ooh, that's tricky, right? Because Is that what the section says? Does it have to be at the time he applies?
If at the time of application submittal, the applicant is the prior owner of the property. At the time of submittal, he was the current owner. It's just at the time that we were, as a city, supposed to do the inspection, at that point, he was no longer the current owner.
Sir, can I
What's the
speak?
city's interpretation here, that I can proceed?
City's interpretation is that you can proceed under this particular circumstance and facts.
I will yield to the city's much wiser understanding of that code section. So the city thinks we can still proceed. The city has offered 12.3. You've asked for 500 to 1,000. I think that's a bit much considering the size of this fine. What I'm willing to do is I'm willing to basically cut the city's offer in half. I could do it for $6,000 and I can give you a certain amount of time to pay. How much time do you need?
Is there anything else the city can do for me?
The city offered 12.3. I cut it in half to 6. I think considering that you came in here with 82, I think you've done pretty well.
Is it possible to do 3,000? And I can do that within the next 60 days.
I can give you more
due to
time.
the hardship.
Well, you'd have to tell me something. I mean, the only hardship you've explained to me is that you have a lot of bills, and I think that's true about most people that come in here.
Yes, and the reason I had it was just due to this property, sir, and it was due to COVID. That was the only reason why I committed up to $60,000 of debt, so I don't lose the property. I had to sell because I couldn't catch up with my mortgage payment, so I had to sell it before I lost the property. And I have all the evidence here that shows that the bank was not happy with me. So whatever the city can do for me, I appreciate it.
I'll tell you what I'll do. I'll move it to 5,000, but that's my best offer. All right, CEU 19060548. I'll reduce the fine to $5,000. How much time do you need?
60 days, sir.
Special time.
I'll give you 90. Yeah.
Oh, I was just going to say, if we could give him more under the circumstances. Sir, just keeping in mind that if it's not paid by that due date, then the original fine amount comes back.
Okay.
Okay.
I'm going to give you an extra 30 days just to make sure that you have enough time. So I'm going to give him 90 days in this for 5,000.
Thank you.
Sir, for the record, can you state your name? I don't think that was ever addressed. Can you state your name for the record?
My name is Chooks Izumar, and property address is 1913 Division Avenue, West Palm Beach, Florida.
Okay.
90 days, right?
Okay, moving on to agenda item number 9. Case number is CE 19090342, and case address is 1029 20th Street.
Case CE 19090342 was cited on September 9, 2019 for repeat violation, garbage can placement, numbering standards, and unpaved parking. This property was taken to hearing on November 20, 2019. The magistrate started immediate fines on the property for the repeat violation. Property was out of compliance for 282 days, resulting in a lien amount of $28,200, and out of compliance with the garbage can violation for 201 days, resulting in a lien amount of $10,050, totaling to an amount of $38,250. Special magistrate, the applicant is the owner who causes violations. The city is seeking 25%.
Sir, can you tell me your name, please?
My name is Jean Rudy St. Cyr.
So tell me what you're asking for and why I should grant it to you, sir.
Okay, so all of this problem happened is because the work that I do, because I'm a church driver, I'm barely home. I'm not really home, and those cars, they're not really my car. This my move my car. When I find out about the problem that the car has been caused, so I asked him to move out. He's moved out, and then there's no issue with the car, but there's some other issue with the garbage can or trash. It's not really me, it's somebody else, because I'm not really home. So I'm here today just to say how we can reduce the cost, because I'm not really, it's my fault because it's my house, but it's not really my fault because I don't do all of this. So somebody else do it, but I'm responsible for it.
So the city has agreed to reduce it from 38,250. I didn't do the math. Did you do the math?
$9,562.50.
So basically $9,500.
$9,500, yeah.
What are you asking me for, sir?
If you can reduce more, it's probably, I would appreciate it.
You got to give me a number. It's currently 38,250. The city has agreed to reduce it to 9,500 and something.
7?
I'm sorry?
7?
So, how long do you need? How long do you need?
8 days.
I'll give you 30.
Thank you.
In case CE 1909032, I'm going to reduce the fine from $38,250 to $7,000, payable within 30 days.
Thank you. So much.
Special magistrate, it's a split order. Are you addressing, is it splitting it or?
Fair enough. Let's just, let's reduce them both to 3,500.
Okay, thank you.
That comes to 7, right?
3,500 each.
Yeah.
When we get this far along in the meeting, my math skills deteriorate rapidly.
Okay, here you go, sir. It tells you how to pay on the bottom of that order, okay? Moving on to agenda item number 10, case number is CE 19090454. Case address is 1377 Palm Beach Lakes Boulevard.
Okay. Case CE 19090454 was cited September 25th, 2019 for clean and sanitary, rental license, COU, inoperative vehicles, fence repair, landscape maintenance, maintenance of the right-of-way, unpaved parking, and outdoor storage. The property was taken to hearing on November 20th, 2019 and was ordered 45 days or $50 a day to comply. The property was out of compliance for 409 days, resulting in a lien amount of $20,450. The applicant is the owner who caused a violation. Special magistrate, the city is seeking 25%.
Thank you, ma'am. Can you tell me your names, please?
Good afternoon. My name is V. Danielle Williams, and this is Morris J. Smith, Sr.
Okay, so tell me what you're asking for and why I should grant it to you.
Thank you. So Mr. Smith is asking for a reduction to $1,000. The reason why he is asking for this reduction is because while he was the owner of the property, he was not the owner occupant of the property. The property was owned by 3 people based on a quitclaim deed. 2 of those 3 were residing in the home. So Mr. Smith did not cause the violations that were cited. Additionally, there was no rental license or rental agreement, so there could not have been a violation for the rental license violation, as the home was not rented out. The home was occupied by one of the 3 owners that were listed on the deed. Once Mr. Smith became aware of the violations, Mr. Smith ended up having to get an attorney to get the quitclaim deed back to him in full, so that now he is the 100% owner of the property, because the occupant, who is also one of the 3 owners, was not taking care of the property. And so once that happened, he brought the property back up into compliance. The property was required to have $1,900 worth of driveway work done. He also incurred fees for sodding of the grass of $955. Essentially, Mr. Smith has paid $3,035 to bring the property up to compliance for a home that he did not live in. Currently, Mr. Smith has just become back to working as normal as a result of COVID, because the city required shutdown of non-essential businesses. Mr. Smith's business was a non-essential business that was required to shut down. The property did come into compliance, though, back in March of 2021. The city was made aware of this when the property was inspected. However, since May 26th of 2021, there was communication with the city that required additional inspections of other properties. Those properties were owned by Mr. Smith. Those properties were also fully compliant with city requirements. So while that happened in June, there was a miscommunication. And so from June until December, nothing happened, and we were not able to come back before the magistrate in order to get the lien reduced. Since then, we have been in steady communication with Ms. St. Hilaire or Ms. Williams since December 28th of 2021. So as a result of the delay, no fault of Mr. Smith's, he's asking for a reduction to $1,000.
What's the city's position on the request?
Yes, so want to address a few things. Ms. Williams is correct on you'll see in the case that the rental license and COU violation was omitted from the file because at the time that the property was in violation, I did speak to Mr. Morris's wife, who did let me know that it was actually his sister who was the occupant of the property. So we did omit that from the case filing. Also, although I do understand that although he was not the one living on the property, he lived around the corner from the property and could see the violations. I also spoke to the wife on several occasions about the violations that were happening on the property, which is why we agreed to the timeline to get it corrected. As you can see, 45 days was given $50 a day, which is very, the city, that was from the conversation that I had with the wife, just trying to get the property into compliance. So the city has been working with this property owner way before this became a violation. Also, at the time of the lien reduction filing, back in May, I believe, is when they filed for a lien reduction. I may not have that number, I may not have that timeline correctly, but they did fail inspections on a few of the other properties that needed to be inspected under Mr. Morris's ownership, which he was sent following up emails by Code Officer Mr. Williams and I believe Officer Thompson, who is no longer here, and was told the items that he needed to correct it in order to get compliance to make it to the hearing. Those items were never addressed. And another gentleman that was attached to this property actually contacted us. And at that time, I, again, resent the items that needed to be addressed in order for us to move forward with the violations. It wasn't until at that moment that I went out and inspected the property, and finally everything got into compliance. The holdup to us even getting here was not on the city's fault, was the fact that other monies were owed to the city that needed to be paid, and the other properties that Mr. Morris owed were not in compliance at the time of inspections. So from the timeline between June to December, that was solely on the owner, not on the city.
Special Magistrate, also for clarification, also for the respondent, the fine that we're talking about here on this particular case came because that property with these violations that we're talking about, that came into compliance February 18th, 2021, so a whole year ago. So the fine has not been running for a whole year.
Yes, and again, I want to note the person who actually re-inspected that property to even bring it into compliance was myself, because again, I was in constant communication with Mr. Morris's wife. So the blame is not on the city. We have worked with the owner several times trying to help the property get into compliance.
If I can respond, I don't want the city to believe that I am laying blame at their feet. I'm not. What I am saying, though, is that the owner occupant of the property was responsible for the violation. She was responsible for maintaining the property. That was the agreement that she had with Mr. Smith because she was living in the property, although he had paid the mortgages. And so once he realized that she was not doing her part to stand up to the agreement that they had, that is when he took the property over. Once he took the property over and it became his solely, he brought it into compliance. Now, did it take some time for us to get here? Yes. Whose fault it is? It's probably both of ours. However, it is in compliance now, and Mr. Smith is asking for a reduction to $1,000 because he did do what he needed to do to get it into compliance.
I mean, it seems to me like the argument you're making is that his co-owner should bear the fault here, and maybe ethically or morally that should be true. Though under the law, he's an owner, so the code in West Palm Beach says that I can't treat him as a subsequent owner, which is somebody that would have something that I could use to mediate the fine. I think in light of the circumstances, the city's offer actually is pretty fair. They're essentially reducing it by 75%. That seems reasonable in light of the circumstances to me. I'm gonna let you have the last word, but that seems reasonable. That's, what, 5,000?
Yeah.
Okay. From 20 to 5, same owner? That's probably better than I would have done in the abstract.
Okay. Can I speak to Mr. Smith? I don't know if he can, if he
I
would
can
be
give
able
you
to afford
time.
it. Give me 1 moment, please. Is the city willing to meet us in the middle? Mr. Smith is willing to increase to 3,500.
Yeah.
What's your thought on it?
35? We'll take it.
Okay, thank you. He's asking for 45 days to pay that.
All right. In case CE 190904454, reduce the fine to $3,500 payable within 45 days.
Thank you.
Agenda item number 11. Case number is CE 2006, CE 20060332. Case address is 1005 West Lakewood Road.
KCE 20060332 was cited on June 26, 2020. Property was cited for failure to secure building permits, required inspections, clean and sanitary, landscape maintenance, garbage can placement, fence maintenance, parking requirements, and outdoor storage. On August 19, 2020, the magistrate ordered 60 days or $100 a day for the work without a permit, required inspections, and fence maintenance violation. The property was out of compliance for 42 days, resulting in a lien amount of $4,200. The applicant is the current owner who caused the violation. The city is seeking 50%.
Did you say 50?
50, I'm sorry.
50? Okay.
No worries. Ma'am, can you tell me your name, please?
Gladys Wong.
I'm sorry?
Gladys Wong.
Gladys Wong. Okay. And you are the current owner?
Yes.
All right, so what are you asking me for, and why should I grant it to you, Ms. Wong?
I'm asking for reduce that amount because I can't pay that right now.
You're telling me that you have a hardship.
Mm-hmm.
So
And
tell me about your
also-
hardship.
Well, I'm a student and I live with my mom out of her social security, and what I can do as a part-time. It's not like a hardship because someone got sick or anything like that. It's just because it's me and her.
So what are you asking me to reduce it to, ma'am?
I don't know, a number as much as the city can. They know that I have been fighting this back and forth and sending emails and calling her like every week. I didn't know that I have that lien on my property. I know that when I came here to ask for a permit.
Ma'am, how are you paying for your house?
Huh?
The fine amount isn't that high. Well, I guess it's all relative. I guess maybe it's not high to some of the things that I see in here, but $4,200, and the city has agreed to reduce it to $2,100. Is that? I mean, that's not the number you want. So you have to tell me a number because I can't read your mind.
And they go as 500. And give me like
Why is the city
30
seeking
days.
50 here?
Because she is the current owner of the property, the violation was work without a permit. A lot of times with work without a permit, because of what is being done, it can affect your neighbors and stuff like that. So because of the violation that incurred, that is why we're seeking 50%. And like you said, this is a low lien amount. I know it's relative to other, it doesn't seem that much. So instead of seeking our regular amount that we would on a bigger amount, I think $2,100 is a fair ask from $4,200. And you have to look at the number of violations that they were cited for here. Work without a permit, fence maintenance, parking requirements, outdoor storage, just several violations added on here.
Yeah, my biggest concern, to be honest, is that the citations on here are not insignificant. The concerns that the city had, including building permits, that's a safety concern.
But
Can you tell me a little bit about what happened here?
Okay, the first thing was the fence. They received a violation because of the fence, the landscaping, and the trash cans. It was outside, not in the street, but they can see it from the street. So we fixed that, and Richard Pansimo, they came to my house. He saw the gazebo that we had. He said that it was fine. And after that, I thought it was done. I came here for a permit. I think it was to paint the house or something like that. I'm sorry, to paint the house or something, for a permit. I don't remember for what. And they say that I have a lien on my property because of the violations that I didn't know. And that's what happened. I have been fighting this since 2020, I think.
All right, this is what this is.
A letter or anything like that saying about the lien.
All right, this is what I'm willing to do in this case. I'll reduce it to basically what amounts to 25%, which is about, I'm going to reduce it to $1,000, and I'll give you 60 days to pay it. But I want a commitment from you that this isn't going to be an ongoing problem, right? That you're going to continue to maintain your property.
I will.
All right, $1,000, 60 days.
Last but not least, agenda item number 12, case number is CE 18050463. The case address is 815 Hunter Street.
Case CE 18050463 was cited May 12, 2018. Property was cited for landscape maintenance, landscape requirements, unpaid parking, and outdoor storage. On July 18, 2018, the magistrate ordered 30 days or $100 per day until compliance was achieved. The property was out of compliance for 1,059 days, which resulted in a lien amount $105,900. Special magistrate, the applicant is who caused a violation. The city is seeking 25%, and I just want to state that this current owner, they own several properties in the city of West Palm Beach and across Palm Beach County, and so these violations, they're not new to them. And the fact that they're such a big company, they've let landscape maintenance, landscape requirements, and these kind of things that are impactful to the neighborhood go on for as long as it did. So please, like, when you look at the amount of what we're asking for, I think that's a fair ask from the city.
Sir, can you tell me your name, please?
Good morning, Special Magistrate Casey Feltner. I'm an attorney. I'm here on behalf of SWH 2017 Borrower LP. Glad this is the last one. You got the attorney for the last one, right? So at the get-go, I would like to contradict some of the city's findings that were just stated on the record. One, we have two properties that are owned by SWH 2017 Borrower LP. We were in constant contact for the last 8 months with the city, along with Arlene Franconero, excuse me. And we brought those two properties into compliance, even though they didn't have any cited violations. So we were working with the city to make sure that they were up to code today. And so therefore, we could come in front of the mitigation panel.
You're referring to two different properties.
Well, this property that's at issue at 815 and another property that's owned by SWH. So there's two properties, not a,
1030 Ortega is the other property that's owned in the city.
Right, in the city. The other thing that I would contest is that we were out of compliance for those 1,000 days. This goes back to kind of the history of this case, which is in May of 2018, the notice was sent out, the finding was made, and compliance was required by August 17th. This is, of course, sod and a broken driveway. The client actually fixed the sod, fixed the driveway in October 30th, 2018, 74 days after they were required to do it. We've submitted that evidence to the city that shows that we complied, and that also shows receipts, and that also shows pictures of how the sod and how the driveway were replaced. So at best, we were looking at $7,400 underneath the court's findings that was issued July 25th, 2018. Based upon matters 3 and 4 that came before the special magistrate this morning, we saw reductions of 15% for fines of $191,000 for repeat violations. This is not a repeat violation. So therefore, we would ask for a reduction of 15% of the $7,400 that should be owed down to $1,110. Now, the reason that it went on as long as it did was we had an agreement with the vendor who was repairing the driveway that he would be the one contacting the city for reinspection. We've looked at the order. I've gone through sections 54 of the municipal code. I find nothing in 54-404 that requires the owner to actually reach back out to the city, that requires them to actually say, hey, I fixed it, so come back out and reinspect it. I know it says it in the order, but even if you look at the order, there's no area code for at the time, it looks like Alejandro M. Lopez was the code officer, so I would draw issue with that. So in essence, we're willing to work with the city. We've been working with the city for 8 months. We're talking about sod in a driveway. We fixed it within inside 2 months, and there have been no cited violations for the property since that date.
Roll back for a second. Are you suggesting the absence of an area code means that the notice wasn't sufficient?
I would make a two-part. There's nothing in the code that requires it, period. And then the absence of an area code does not provide actual notice as to, I mean, don't get me wrong, I think you can glean from the fax number, you know, how it is, but it does appear to be insufficient on its face. But I think the bigger argument here is we fixed it. We fixed it inside 2.5 months. We've provided evidence that we fixed it inside 2.5 months from the citation date. So the 25%, while we appreciate the city working with us, we would look for a 15% reduction of the actual 74 days that the property was actually out of compliance.
City's response?
Yes, I want to just go through over a timeline here because he did mention former Code Officer Alexander Lopez. So this case went to hearing on July 18, 2018, right? On August 17, 2018, we have a notated comment here from Officer Lopez where he spoke to David, the contractor for 815 Hunter, who will be doing the driveway repair. I provided him the building department number to him, right? At that time, he spoke to one of the contractors that you guys hired stating that the landscape and all of that, the issues with the driveway will be done and he's going to put the proper permits in, right? Then we move on to August 20th, 2018, where he stated that the property was in compliance. This David, where Alex went and inspected the property, he notated the property failed, the dead grass replacement is still there, and driveway is still in disrepair. Right? On August 30th, he submitted the affidavit of non-compliance. Right? It wasn't until, again, July 14th of 2021 that we received, the new code officer in that area received a phone call stating that the property was in compliance. And the driveway permit, the final review on that was on October 16, 2018. So that's when the driveway permit was actually applied for, but the work was not done, nor the landscape requirements. It wasn't until July 14, 2021, as stated by city ordinances, as we stated with many of the cases here, it is not the city's responsibility nor the code officer's responsibility to keep going on a property to let you know, hey, cut the grass. Hey, let me know you're in compliance. This is why we go to a hearing. You come and speak to the magistrate, they give an order, they tell you have this amount of days to get these items done. And he did do his due diligence and he spoke to a representative for this property and the work still was not done in a timely manner. So if it went longer, then you believe that it did, that is not on the city. That is actually the owner's responsibility.
Okay,
That's the city's
Special Magistrate, if I may respond, the fallacy on that argument is, so the city's allowed to sit for 3 years after we provide information that shows that it was complied with, that the sod was fixed in October 16, 2018, that the driveway was fixed in October 16, 2018, and they're allowed to continue to fine for 3 years at $100 a day?
So let me see if I understand factually what happened. So you're saying that your client submitted information to the city that they were in compliance in October.
For the driveway. And then what failed to happen was the vendor failed to reach back out and say that the sod and the driveway were actually fixed as of October the 30th, 74 days after 8/17, and that therefore, because no one reached back out, and that's in the affidavit that we submitted for the mitigation process, that because that 3.5 years later, when we were applying to do a special exception with the city for, was it an easement? Palm Beach County, it was a special easement. That's when we were notified of the lien against the property. There was no notification of the lien or the continued rolling $100 a day fines for 3.5 years for a driveway and sod. That was fixed.
Yeah, as stated, Special Magistrate, if you look in the case file, there wasn't any review requested until July 14, 2021 by the owner. So even if you put in a permit, we are the code officer. It's not their responsibility to, if you did it after the fact, it is up to the owner and or the contractor, your representatives, to reach out to the city and state, hey, we are not completed with the work. We need it inspected. This was not requested until July 14th of 2021. And that wasn't inspected by Officer Luster, who was the new code officer in that area. At that time, she was the one to finally bring this property into compliance. The request from your client representative wasn't made until last year, July. So the city did not sit for 3 years. The owner never made, the contractor that you guys hired, the people that represent your company as a whole, did not felt it was they're responsible to let the city know that, hey, we are now in compliance after the fact. Let's state that too. They were not in compliance with the order the magistrate made. They were in compliance after the fact. So by that time, neither the code officer would be checking every day to make sure, hey, did this property go into compliance? We would not be doing that. You have an order in your hand that tells you when this property should have came into compliance. Whoever chose to not let us know, that's not on the city. We did our due diligence. The moment that it was requested that we do an inspection, the officer went out there, we looked at the file, and we put the property in compliance. So if it exceeded the time that you believe, that's not on us. That is the responsibility of the owner.
Let me jump in a little bit, because I think I understand the nature of the argument. The petitioner is arguing that the petitioner shouldn't be responsible from the time that they brought the property in compliance, that the obligation to let the city know is not on them, and the city's arguing that the city doesn't have an obligation at that point, that it belongs to the respondent. So let me ask the city attorney, what's your position on that particular legal issue?
I believe that, there's notice in the notices of violation and in the orders that the respondents or property owners do have the obligation and responsibility to contact the city when they believe that they're in compliance.
And could I ask where in the code does it allow for that proposition to be put into the notice and if I can just get it on the record, of course, for appellate reasons, where in the code it says for the notice of violation and where it says on the findings of fact in the order?
Special Magistrate, I'd have to research that. We would have to recess to do that, but if you'd like to go forward otherwise. As well, the underlying case was not appealed.
And the fallback position, Special Magistrate, would be at $100 a day in accordance with the order, 8/17, 74 days out of compliance till October the 30th. Fallback position will be $7,400.
It's an interesting legal question, because the order does require the respondent to notify the city, and as a practical matter, in a city the size of West Palm Beach, putting the burden on the city to follow up on each order seems, I don't know, it's a
problem, but it's great.
On the other hand, I do find something to the notion that at some point should the city check on it? Maybe. What's that number? I don't know what that number is. So I do accept that there's some mediation associated with that. The city has offered to reduce it from 105.9 to 26, is that right, if I read
Yeah.
that correctly? 2645, and sir, what are you asking me for?
The initial was, of course, 110. If the court agrees that it would be 15% of the 74 days. Otherwise, the fallback position would be somewhere in between that and 7,400, which would be in compliance with when the property came into compliance for the two violations, the sod and the driveway, and that's $100 a day in accordance with the order CE 18050-463.
That assumes that I'm willing to accept the notion that you're off the hook when you completed it, even if you didn't notify the city. I'm not sure I agree with that proposition.
But
go ahead.
The problem that I have with that, Your Honor, is even if we were required to, at some point, actually notify the city and have the city come back out, we still brought the property back into compliance on October the 30th. We cured the wrong. And so to charge an exorbitant fee or fine after that is a windfall.
Just to push back on you a little bit, that's a bit of an open question. You have evidence that somebody's going to say they did, but whether or not you were in compliance is when the code officer goes out there and sees that because I think you'd agree with me, there's more than a few cases where somebody says, hey, I'm in compliance, and the city inspector goes out there and goes, you're close, but you're not.
I would agree, but in our mitigation package, we submitted not only receipts, but pictures that showed compliance.
Well, let me ask, is the city, I presume that you've reviewed the mitigation package. Is the city in agreement that they were in compliance at the time that they said they were?
And I've spoken with Arlene Francanero about this and submitted that entire mitigation package, right? To the city attorney's office with pictures. I have the email communications if I need to forward that.
I don't disagree if you say that you did. I just don't have an independent recollection as we sit here at the moment.
Sure.
But let me see. I'm so sorry. Do you have that documentation with you as well, Mr. Phillips?
Grab my laptop, one second. Sorry, I have to remote in here. That's the beauty of technology. Unless, Julie, do you have that email correspondence when we sent the mitigation package with all the pictures, and that was in August of last year, September of last year?
Was this submitted in conjunction with the request for reduction?
So it's funny, Your Honor. What happened was when Mitchell was in charge of it, I think was the owner, we had a telephone conversation, Cindy Dyson and myself, Casey Feltner, and Arlene had a telephone conversation where Arlene was given, according to the phone conversation, the ability to stipulate to a lesser amount of fine. After that, Mitchell, of course, I guess no longer works here. That changed, and then the position of the city changed where we needed to come in front of the special magistrate to go in through the process. So we've been working with the city since summer of last year, trying to get this down.
I presume it hasn't been with you, with the current city, with the assistant city attorney that's here, Arlene. But you've been working with Arlene,
I have.
Give me a moment. I think I found the packet that you're talking about.
It should have pictures of the driveway, the fixed side, and it should have the receipts for the work orders for the driveway. And just an aside, Special Magistrate, we had to pay $7,510 to get this into compliance. So,
I think the issue was, and Special Magistrate, I'll bring my computer over so you can see, and Mr. Feltner, you can also look at it to
Sure.
make sure you agree that's what you're referring to. It appears there's some photos. There is a proposal from SMS Assist LLC.
which is our internal work order.
There is an invoice, and I think the invoice was September 4th, 2018. The problem is I think what we were looking at, there's also an invoice 10/30/2018. Was the photographs were not dated, and I think you and I were actually trying to work on when that actually all occurred. I could be wrong, but if you have further information on that, that'd be great.
I do. We have a email from Julie Hines to Valerie Luster showing, and this was on July the 13th last year, showing an invoice. I won't do the invoice number. I don't think that's required for the record, but invoice date 10/26/2018, 75-1. Work order is clear to all active violations currently given by the county authority governing this parcel. Tech will be working on the process and diligent permitting other items necessary to bring the property in compliance. And I think that aligns with the city's recitation of the facts on 10/16. We were, of course, pulling the permits to do all the work. Those are old photos, right? Those new.
Those are the compliance photos.
Those are the compliance photos.
Yeah.
Okay.
So I think you've still got an invoice as late as October of 2018. Which I believe is much more than the 74 days that Mr. Feldner is proposing.
No, it aligns, because if you take from August the 17th to October the 30th, that's 74 days.
Okay,
Yeah.
all right, I apologize, yeah, but then I think it was just the final, being able to pinpoint the final date that it was done.
I think we can all agree something was done. The question is, did it come into compliance? And that's one of the reasons it's important to get a city inspector out there to know. I mean, I'm not in the position, based on the limited photographs, to really make a determination whether it was actually in compliance. It looks like work was done. Was it sufficient? I don't know. How am I supposed to know?
But wasn't the city on notice that work was being done? I mean, so that kind of cuts against the city's argument that they were under no obligation to go out to do anything. They were the ones who found the property in non-compliance in the first place.
Well, it's a big city. I mean, if you submit something to building, it doesn't necessarily show up for code enforcement.
I just want to know, that's not the city's position. The city's position is that when your contractor reached out to Alex Lopez at the time, the permits nothing was put in. So the time that the magistrate gave to get everything in compliance, you surpassed that time. So on the 17th, when Officer Lopez spoke to your representative, he did look for permits. He went out and inspected the property because that's what he was told. And once he checked those items, they were not done. And as you've even stated, the permits weren't even put in until October. So how is that the responsibility of the code officer to know that?
So
if the representative does not reach back out to let us know.
But the code officer is allowed to survey the actual entirety of the city limits, find violations, and then issue the violations, let that run for 3.5 years, and has no obligation. I just want to make sure I'm clear for the record that the city stance is there's no obligation to go back out at all to check compliance for 3.5 years.
Well, most responsible owners do reach out to us and let us know in compliance with the magistrate's order. At the moment that they get into compliance, even at the hearings, the magistrate always make it a point to say, hey, please reach out to your code officer once you get this item complied.
And that's the factual scenario where you're hiring a third-party vendor to do
the code states. The code states it is the responsibility of the property owner to maintain a property.
Let's get back to because I think I understand both positions here relatively clearly. The current fine is $105,900, right?
Correct.
The city has offered to reduce the fine to $26,475, and respondent has asked for, I guess you had two positions, right?
We would be happy with $7,400.
So the respondent has asked for the $7,400. I'll tell you what I will do. I will reduce it to $10,000 flat, payable within 60 days.
Thank you, Special Magistrate, and thank you for the city's time and for Arlene's time with help on everything. We really do appreciate it.
It's an interesting argument. I got to give it some thought because I think it's a persuasive
Save the last
argument.
one for an interesting legal debate, right?
Yeah.
Thank you, guys. Yes. Thank you. Thank you all for your time. Sorry to make the last one the most interesting.
No, always fun. I think that's it, right? That's it. All right, seeing no further business before us, this meeting's adjourned.